Welcome back, everybody. I hope you enjoyed your lunch break. Now that we've resumed from our lunch break, we will resume with Ken and Tara's pre-recorded testimony. This will be the third portion, and it is or it is an hour and 51 minutes long. So we'll go through this portion, and then we'll take another short break before we watch the final portion of Ken and Tara's testimony, which is approximately a half an hour long. And then after that, we will have another short break before moving into the testimony of Bill English. So we'll now resume with the third video. I'll just give them a couple more minutes to rejoin.
I'm here, Kelsey.
Hello, hello. Okay, all right. Thank you, everybody. Welcome back from the break. As I said just before we went to break, I only have a couple further questions for Ken and Tara before I pass it over for cross-examination. We will first go to Kathleen, then to the province, and then to Judith Ray with the Innu Nation. And then if there's anybody else who has questions arising and we have time, we can go there. Please remember that when you're asking your questions on cross, that the testimony the witnesses are providing today must relate to their work under the scope of the inquiry. We can't ask the investigators to speak on matters outside of their scope or matters that do not relate to the inquiry. Further, in fairness to the witnesses, please recall the limitations they spoke of earlier, such as documents and witness availability when you are asking those questions. So I'll just ask my last couple, and they are about the death investigations. So as I said, we've heard quite extensively from you guys, and we've been very grateful to have that, the death investigations. But aside from the issues already discussed and the examples provided, is there anything from any of the death investigations you would like to highlight or discuss further in relation to the systemic issues?
I don't have anything further.
No, I don't have anything further.
Thank you. And finally, the reports on the death investigations that you submitted, those were submitted prior to the hearings which occurred for them. Did anything arise at those hearings that you'd like to add within that report?
I don't have anything to add that was discussed during the hearings. That was not in the report, if that's how I understand the question. Yeah.
Yeah, no, and I saw the hearings actually as affirming the quality of the reports because they were compatible. The content of the go-arounds and the report itself had a certain seamlessness that I appreciated. So nothing to add.
Excellent, thank you. And I thought I had one final question, but actually it was one that has been submitted by Kathleen. So I'll now conclude my questions for you, and I will pass it over to Kathleen to bring her questions on behalf of the family she's representing. Yeah, I will hand it over there now.
Hello, thank you. Nice to see you again, Ken and Tara. My question is about cultural disconnection, and perhaps the answer to my question may have been implicit in much of our discussion, but I just wanted to make it a bit more explicit. So, as you know, my client is James Poker, Thomas Poker, the father of James Poker. And James was 10 years old when he went into care and aged out at the age of 16. And in your report, you talked about how during his time in care, James lost critical connections with Innu culture and traditions, which would have included his connection to the land and learning how to live on, be on the land, to navigate and survive. When he returned to Natwashish, there was no transition plan to reintegrate him into culture and community life. But James's father has spoken about a family camping trip which occurred shortly after James returned to the community. And he said it was quite clear, he observed that James was very uncomfortable in the community and that James made comments about how he didn't know anything. Tara mentioned multi-day walks, and this is, it kind of leads into this as well. We don't know exactly why James left the community on the day of his death, but one theory is that he planned to walk to Hopedale, which would be an overnight walk. James's knowledge of an experience of Newchemit and the country, as we just observed, was negligible. And James's death was accidental. He became lost and died of hypothermia on the Labrador Sea. So in this respect, would James's loss of inner knowledge and culture be a contributing factor to his death?
I can start with my response if that's all right with everybody. I would, if you're asking it as a question or if you're wanting me to agree to a statement, I would agree that the loss of, the connection to culture, the land base living, was definitely a marked loss in his life. And it was something that he yearned for. And I also agree that when he came back, and rejoined that type of lifestyle, that there was a noticeable disconnect with that was observed by his father and then likely experienced by James himself. And this was the way that it was, I guess, described to us in the interviews was, that, they came back and, didn't fit in, wasn't, fully accepted by peers, that were, left, 6 years prior or so, right? And that there wasn't, even, I guess, like a stable place for him to stay when he came back to the community. So that's what I'll say for now.
So I'll say, he was didn't have the opportunity to know the nuances of his life on the land, and it may well be, and this is speculative, and the question is speculative, of course. He may well have not have known the risks he was taking because of that. He had no experience with learning about his environment. So in that way, I could see a connection between his death on the ice. He just he was a bit alienated from that environment, and that makes that environment very dangerous for him.
Thank you. And that's kind of what I was getting at. We have talked about, in your reports have talked about the healing, the disconnection, and the emotional distress that the loss of culture caused for him. And I realize that it is speculative, but it was intended, and James wanted to return to a community where he would be in very close proximity to an environment that he had very little knowledge of. And I think it kind of fits in with the lack of foresight that when someone is being returned to that community without any preparation at all. And I'm just wondering, does that fit in with your own observations of the transition planning, the poor transition planning, and consideration of what the young person's life was going to be like when they returned to the community?
Yeah, I believe that that was very well like a contributing factor, as I emphasized earlier. And I just wanted to kind of bring note, like this wasn't something that was anticipated at the time, by even by the professionals or the social workers in place. They they didn't think that the return of him to his community would result in kind of further isolation or alienation or loneliness. That was probably not what anyone anticipated. um, you would I would and I'm I would believe that someone returning to their community would have a reunion, and a reconnection, uh, and not that that is their belief, and that when they actually did return to the community, the adjustment and is related to the time that was lost, and that was very difficult to overcome.
Okay, thank you. I have nothing further.
Thank you. We will now move to the provincial government to ask their questions. So Kathy or Phil, will both of you be asking or just one of you?
No, I'll be asking the questions for the provincial government. I'll see.
Excellent,
Just
thank you.
grab my piece of paper.
You can proceed whenever you're ready.
Absolutely. And just say up front, my questions aren't really directed at either Kenn or Tara specifically. So whichever one of them wants to jump in, or if both of them want to, that's certainly fine. So I'm going to try to ask them more or less in the order that the topics appear in the final report. And my first question is, on the issue of gas sniffing, which I think might have been topic 4. And you identified the gas sniffing crisis as a major factor, I think it's fair to say, in most, if not all, of the death investigations. And your report also highlights the failings of sending children out of province for various reasons. And I just wonder, are you able to give your, I guess, views? How would you envision some sort of sustained addictions treatment happening in community? Obviously, Natwashish in particular, but both communities are small communities, relatively isolated communities, again, especially with the Natwashish. Do you guys have any particular ideas on how that could look?
Let me just this is not the only community that has addiction issues. So what has worked in other areas is good old-fashioned youth work, on the line, relationship building, youth to youth development, whether it be through sports, which it can be, hockey and baseball are both alive and well. And I don't want to be one of those to have a simplistic saying playing hockey is going to change it, but it's part of building in quality of life into the life of those young people, and giving them also opportunities to excel however they want to excel, whether it be staying at home on the land or becoming a lawyer in Halifax. It's going to be entirely up to them. But just having an environment that supports that. But particularly these cases, these kids that were the subject of our inquiry, they all had particular needs. Some would say special needs. And we know that children with special needs that are unmet, service-wise, and allowed to fester and develop, become worse over time. I call it spiraling, just to give you a visual on it, but they all kind of spiraled. And at the conclusion of the spiral, I believe for all of them, there was gas sniffing. Some were terribly addicted, and it would be an everyday, all-day event. Others only when they were in distress. But it was just a common experience. And so it says it's not just hockey's not going to help them. Well, it might, but what's really going to help them is an intensive clinical program that's offered in the communities that would include indigenous ways, but also the best of what the West has to offer with respect to medication management or, therapies that would be applied specific to the individual child's needs, some kind of clinic. What I just, in terms of a whimsical moment, and I'll conclude here, I thought, why can't Ranch Elro, which is a pretty good treatment center, be in the community in some collaborative way to handle those special needs kids? And, about 10% of the kids are going to need those kind of supports. And I'm speculating on that number, but that's been my experience. So gasoline seems to have to be woven into terms of, the curative end of it, into, a multiphasal, multimodal system of service development, everything from primary, secondary to other interventions. Yeah, that's, I'll stop there. That's quite enough, I think.
Yeah, I would echo what Ken is saying, but also just kind of a focus on community collaborative and collective efforts to educate, provide just almost like a community knowledge base, of, of of the risks and the impacts, but in a way that does not, in a way that that normalizes well-being and prevention of that.
Yeah.
So a lot of community healing and efforts, that focus on that. That is community led.
Mhm.
Um, and just that all of the helping services that are available in the community wrap around this issue and work together to provide a solid educational base and options and activities. I totally agree with options and activities for youth, but also just a strong identity. In different stages of life, there are different roles and responsibilities in a family, and the focus and celebration of those types of passage of rites of passage, and life stage movements, whether it's from child to adolescent, from adolescent to adult, to parenthood, being an aunt or uncle, all of those different things have significant value and meaning and a role in the community.
So for my conclusion on this, it has to be built into a broader developmental process, service development, community development. I think the community might try to rejuvenate as much, and this is the part of divesting yourself of the colonial yoke, is develop this, truly this, it takes a community to raise a child. Further, they're intact in so many ways. They're going to need to have a collective effort on this. That's a challenge, but it's certainly positive. But I just wanted to say, part of me also wants to just be really practical and say, well, how many gas pumps are there in Natrishish? What about, there has been, for example, in isolated communities in Australia, control over the gas, and using a gas that has non-toxic properties. Like that's happened, and it's been relatively successful in some areas. So I think there needs to be a bit of research about, when I say multimodal, it's not just about community development, it's also making access to gasoline. And I know people will say, well, if it's not gasoline, it's going to be something else. But in a closed environment, closed system, like Natrishish, not so much in Sheshi, but Natrishish, I think they can do stuff that others can't.
That kind of, I think you've sort of answered one of my other questions, but I'm gonna jump ahead a bit and ask that in case you have anything else to add. And one of the questions was about, I guess, the importance of land-based healing. You've talked about, I think, in a couple of your individual reports and touched on it in your, I'll say your writ large report, I guess, the failings of over relying on Western medicine versus the Innu outlook, which we know is very different, and we certainly learned is very different, which would put more value, I think, on a more land-based, elder-led programming, perhaps. Versus, you've also highlighted the importance of these children getting appropriate psychiatric care and appropriate medication, which is more of a Western-based philosophy. And I guess, how would you suggest, or what are your ideas for balancing those two competing viewpoints?
I don't think they have to compete. I think they're quite compatible. What's required is relationships. Well, what's required is some kind of reconciliation process that will conclude with a new set of relations that will allow true collaboration and communication and service development. The West has a lot to teach, and certainly the Innu have a lot to teach. And what can happen as a result of that mutuality is golden, and is actually that's where rests the solutions that we're all striving to achieve. So that's why I sort of react sometimes when people say, "Oh, we're going to leave the Innu to do their own thing." Well, yes, indeed, leave the Innu to do their own thing, but offer your hand because it's a mess you're giving them. So, in simple terms, I see this as helping clean up and move forward in a very actionable way.
I don't have anything to add to that,
Okay.
Catherine. Thank you.
Just to go back, I guess, a little bit, another couple things. I'm realizing a lot of my questions have to do with how do we balance very different issues that come up. Your report speaks to the importance of Innu families feeling empowered and being a part of the decision-making process. Being included in clinical decision-making, things like that. And I guess, how do we balance that in situations where a family may come to CSSD or SSWB or whatever acronym in the future and say, I want my child to be taken to Rancho. I want my child to be brought out of the community. Are there any guidelines or suggestions for that sort of situation?
Well, first thing, if a parent is given up, there's interventions required, and maybe that would be because they're overwhelmed, their request. But a skilled practitioner with available resources, with the relationship with the family, can say, "Okay, I get that. Let's sit down and see if this is necessary. Let's have a good communication, good assessments, good evaluation. Get it going with respect to what's the best possible plan. If the relationship is broken down such that there is risk, and in one of the cases, the kid was going to burn down the house, and there's some serious stuff. So that can't be ignored. Common sense has to prevail, and what I mean by that is let's make sure nobody dies. Let's make sure nobody gets hurt. That do no harm. The tenet is writ large on this, but usually when parents are at that point, they don't really want to have their kids removed, but they see that as the only option because, quite rightly, that has been the only option. So again, I'm a bit whimsical on that. Tara, you want to?
Yeah, like what we saw, is a pattern of when the gas sniffing, or the behaviors, and the unsafe conditions that children were in because of the the persistence of the issue around gas sniffing. The first resort, was removal, evacuating them on an emergent basis to a resource, often out of province. And when we look at the files prior to that, prior to this, intervention, there is limited information around, what kind of what kind of services did they receive prior to this? How did it get to that? And so a parent to come forward to say, I need help, I can't do this, that that shouldn't be their first kind of entry into a service industry of helping, so transforming, that where that would be a last resort option. And here are the things in place, whether they're family-based or community led, that are strengths that we will grow and build on. And that is, I guess, how something that is going to take a lot of time, to undo. These issues didn't happen overnight, and they were not a result of their own decisions and their own choices.
I have a question about, I think this was actually topic 4 on the service gaps. And you've highlighted it, and it's come up a number of times in the circles that families have concerns because their social worker is on this fly in, fly out rotational schedule. I think it's probably fairly non-controversial to say that a lot of people, not just child protection, have difficulty staffing remote northern communities, and I'm assuming that's across the board in Canada. And this might be something you answer based on your own experiences in other jurisdictions, but like what suggestions or how would you see ideally this looking like in a community like Nawashish? Shashashi is a bit different where it is so close to Goose Bay. I don't think it's quite the same issues with retaining staff, but certainly for Nawashish, like what would what would you see working as some sort of alternate model?
Well, what will work is the aspirations of the Innu in terms of Innu-led services that would be provided by community members to other community members, and that's the aspiration. Short term, first of all, acknowledging that fly in, fly out is not working, and that it might work if it were to be perhaps amended in certain ways. And that would be in partnership with Innu staff that would remain on site, and the fly in worker, fly out worker would be less important, except for exercising sort of the legislative responsibilities of the role in child protection. But the actual work being done, it has to be done locally. And there's, that I don't know enough about what, the strengths and weaknesses of the community is right now with respect to providing that. I know that they got a lot on their plate, but but right now that will never work. And we heard that in a few other circles that it's still happening, the fly in and fly out, and that they're just waiting for change. So it'd be great if the province could see itself, or the feds, and part of the development of the Innu program under C92 would start flowing some resources so that local folks can be trained to assist the CSSD, and in terms of home visiting, and just making the all important relationship aspect of child protection. That's what is required. So it can be part of the development process, in my view, and it would be if I was writing up, a development plan.
Yeah, I would echo what Ken said, and I would also just say, like, in a fly in and fly out model, that there are many models like that, not only in child welfare, but like in justice and health, in remote communities that may or may not work well. I think a very important thing to have when there's a model like that is the handover of effective communication, and understanding what the case, the cases are where they're at, and what is going on with each of the cases in the community. There should be common knowledge between the workers that are rotating, and a common system of communication that that would allow that information to be available to a covering worker.
Let me see. On the topic of, I think topic 7, the mental health and clinical care, I think, and you've drawn attention to the issue of children not being, I guess, properly assessed for various mental health issues, or these issues not rising to the surface. I guess the position or the statement I would make is that we expect social workers to be competent and experts in dealing with protection and risk assessment, things like that. They wouldn't necessarily be expected to be experts in mental health, and that these services should really be provided or available to children without them needing to be in the care. And I think you both agree with that, but is that the case? You would agree with that?
Yes.
Social workers need to know when to call in the professionals. The mental health, the psychiatrist, the psychologist, that's their job. It's not to actually provide those services. Case management is really what their job is when they're not trying to manage the crisis and the behavior that crisis ensues. So if you step back to the job, it's like bringing the necessary resources together for a particular child based on their specific issues. And that would include, as I said, mental health supports, both in assessment phase, should be early on, and treatment phase as the problems become more manifest.
Yeah,
it's kind of what social workers are trained to do. Sorry. Yeah, go ahead.
Yeah. Oh, and we also emphasize, the need for, kind of trauma-informed approaches, to care, to case management, responding to mental health, and clinical decisions. And I just wanted to highlight that, oftentimes when there is a language barrier, so when you're doing a Western-based assessment on a child who doesn't speak the language and is not, comparable to, I guess, the evidence base that the assessment is uh, based on, so they're dealing, you're measuring, using measurement tools that were not developed with the Inuit people or First Nation people. And then if there's a language barrier, often the diagnosis can be misinterpreted or misrepresented because of those issues in play. But then on the other hand, they could also be accurate, based on the severity of the condition, the cognitive level, so it is a real fine balance. But there needs to be, that recognition of the impact of, the traumatic experiences historically, and in the generation or in the life of the person, and people being looked at or needing services.
So just to sort of, I think what you're saying is the things like intergenerational trauma can impact the accuracy of these tests and these models that are used, and a language barrier will also exacerbate those difficulties.
Yes.
Okay.
Language and culture.
Yeah.
Yeah. So if you're like in, the city of, Toronto, and you're having, a clinician, from a different province and a different whole, providing an assessment. There needs to be great care and,
Yeah.
understanding, the impact of trauma and the
Good.
understanding of language barriers and things like that.
It's important for the inquiry to just appreciate the subjective experience of these kids who were placed in, and a lot of them went to Southern Ontario. They went to, anybody familiar with Belleville, Kingston, that area up up to Highway 7 there? This is United Empire Loyalists, and I have a cabin there, and so no disparaged comment about those folks. They are what they are. They have their own unique culture. They're certainly a part of the Canadian mosaic and all that stuff. Completely foreign land for these kids. I can't imagine how it's like us being dropped in Afghanistan, or some other culture that is so vastly different from us. It wasn't just a language, it was like how to behave, all those things that we take for granted as socialized folks from particular contexts. These kids had to struggle with. And not only did they have to struggle with it, they had to cope with their distress at the same time that they brought with them. Their cognitive issues, their trauma, their emerging, and all of them had emerging psychotic conditions. Not all of them, but most of them. It's unbelievable, to see how they managed to do as well as they actually did, notwithstanding their tragic ends. They were strangers in a strange land, and they were vulnerable at the same time, and it was just pretty sad to watch.
And this sort of, I think, flows into that. And you spoke about this in your when you spoke earlier today. So I may be retreading the same ground. But I don't know if you have anything else to add about the issue of using organizations like Tuskers, because I think, you say in your report, and I think it's clear that your preference would be to use the CAS because they're held to certain professional standards. That an organization like Tuskers would be, but also at the same time, you said at one point, and this might have been in one of the children's reports, that they probably provided more, I think the term was culturally sensitive than CAS would have. So like, how do you kind of, I guess, square the circle?
Well, Shelley Oakman, the practitioner associated with Tuskers, took it upon herself, for example, to go to Newfoundland, to go to Labrador and become familiar and to make outreach calls and such. So she personally, even though her system was not accountable, I'll give her some credit. She felt some level of accountability and did try to engage the family. So, it's a person acting in a particular context that wasn't really supportive of her acting, but because of her sense of purpose, and I support this, she saw differently. But she didn't have to. She could have just been a purchase service with no accountability for under the legislation and the standards and the guidelines associated with monitoring a kid that's in care. But when you look at what's required under legislation, I don't want to say laughable, but it's highly concerning. For kids in care, their social worker, for example, sometimes doesn't have to visit within 90-day periods. I mean, how do you have a relationship with a child when you see them every 3 months? So the system is, our orders were specific, our reports are associated with that. But if you want to talk about child welfare in general, those conditions still exist everywhere. And one of the things the Indigenous sector is doing is saying, that's ridiculous. We want to see our kids a lot more than that, and we want the money to be able to do that. And of course, that's where you get into another area of problems, as you probably know, well, certainly the Innu Nation knows. So, yeah. I'm taking the opportunity for a soapbox here. I apologize.
Yeah, I would just add that the use of kind of a third party I guess, coordinator of, the placement of these children, does need to still be monitored, supervised, by the mandating or jurisdictional body. So they're and so that's one. And then the other one is, the other point I wanted to make was that, despite the efforts, of, the third party, or Tuskers, or Shelley, or, that the practices that they implemented, in their services, there was still a huge disconnect in how that was shared. So if there were monthly reports provided to the case manager, that maybe documented incidents, it wasn't always known that these things were shared with the family, or if they were just passed to the family, how were they then processed and read and understood by the family. So those are, you know, that's just what I'll add to Kenn's comments.
The issue, there's been a lot, perhaps one of the most overarching themes, you just touched on it, is the communication. And I mean, you've both worked as social workers, and I'm sure you'd recognize communications as can be difficult, especially when there's these cultural differences, but perhaps in any situation where a child is in care. Are there any specific recommendations you would make for improving communications, I guess, other than a general do it more? And maybe that's one of your recommendations, which is, I'm sure it is, but is there anything more specific or more, I guess, culturally attuned you would suggest?
Tara, you want to do that?
Well, I guess, well, the use of, you know, so having like a community liaison, and I know we kind of touched on this, like Ken touched on this, like around having, people, who work in collaboration or with the provincial agency, that have, knowledge, or who are Innu, um, would be kind of like a starting point. And I'm kind of just looking back in my own practice, like I was a First Nation social worker, but I worked for my community in the provincial system. So that's my experience. So to transfer that to, um, not necessarily seeing that, in the community of Natwashish, uh, um, that the use of, and some of the workers that we spoke to also had, there were some community contacts, that they relied on, to provide resources to them, such as knowledge of the community, knowledge of the language, that it didn't seem like that was formalized in any way. Whereas, even in systems, in the system that I was familiar with, there was, even prior to, our provincial devolution, there was the use of what we would call like childcare committees, where there was, people in the community that did meet with the provincial agency to talk about, placements or family connections or language, so that kind of thing, we saw it kind of informally, but not anything formal as an expectation of the, the mandating agency or the provincial bodies.
We used to have something called case aids. And, while I don't promote that as a long-term solution, in the interim, as the Innu develop, yeah, hiring local people to go to that office with the social workers and be the continuity and the relation and the cultural guide and the icebreaker and all those things that are required to get that kind of relationship that you want. Because they can be a bridge, right? A really good bridge in the short term. So I think things can be done today, or relatively quickly, to attend to that and to mitigate the issues. that prevent relationship by hiring the Innu to hold some authority in terms of engagement so that they can make that relationship happen. Now, maybe that's even hard in and of itself, getting case aids. Let's let's be frank. Child welfare is not anything that is easily done, and we know that when you're immersed in a child welfare scenario that is highly conflictual, and it's your family membership and your community that you're dealing with, how difficult that can be. So this is not for the faint-hearted, but it starts with the dialogue, um, and a great dialogue that and I want to have this opportunity to say this, this talking circles that we've all experienced over the past little while would be a great place to go to say, how do we get things better in this community in terms of accelerating the development process for the service sovereignty that is emerging under C92, but also just today providing better work because it can be done.
Just to kind of follow up on that question, I mean, recent amendments or changes to the legislation that require serving notice on Indigenous representatives, which often leads to Indigenous representatives being involved more closely in the files and attending court. Do you view that as being part, perhaps, of the solution for a question like this?
Sure, but by the time you get to court, things are already broken down, a lot of the time. So I say build this in earlier into the process, and that you're talking about band representation, and as we know it, at West anyway, the important piece of the service continuum, yes, but it doesn't fulfill all the needs, service needs going, at any point in time. Tara, I don't know if I've
Yeah,
been clear.
yeah, I don't have much more to add, but other than that, I believe that, the work of the we didn't, it wasn't within our scope or anything to look at, the work of or the development of services, to date, but I believe that there is on a good, there is, the Innu Nation is on a path, and the path is supported, by federal legislation and funding, and that there is like a lot of growth in that area. Yeah, that's all I can add.
And the only other question I have is, I guess, on the topic of aging out and aftercare, which was certainly, again, a theme in several of the children. And I guess the question is whether they age out under the legislation when they're 16 or 18 or older. At a certain point, CSSD or SSWB loses the mandate to be involved. And oftentimes there's situations where the families, for various reasons, don't want anything else to do with job
Sure.
protection or CSSD. And I'm not saying that's not understandable. I guess what can be done there to kind of try to bridge that service gap when a child is no longer young enough that they can be, I guess, I don't want to say forced, but when CSSD can be involved and when they lose that mandate.
Anybody who's raised kids or raising kids, 16 is they're babies. So we all know that. You don't need an education to know that. And how it got to be that was this aging out business was part of our duty to care. It just, the whole thing has been wrong, and it's being corrected, thankfully. And I'm pretty sure as the Innu draw up their law, that it's not going to be some kind of arbitrary statement with respect to somebody's a child at 15 and an adult at 16. So that being said, what was interesting in this scenario was there's a big gap. If even a kid, and one of the kids could have used adult protected services, they didn't exist until he was 18. So there was 2-year gap in terms of anybody being responsible for the good and welfare of this child. So yeah, it's the aftercare scenario is being cleaned up in other jurisdictions, based on reality and based on you know, a full appreciation that if the state's going to remove a child, the state has an obligation to raise that child up in a good way. And it doesn't mean kicking them out at 16. Anyway,
Mhm.
Tara?
Yeah, I know that there, in today's practice and opportunities, there are definitely action taken around aging out, preparing people who have been in care for a long time uh, to live beyond care on their own. But from I guess from a practice standpoint, there that also the reintegration and the aging out often involved trying to look for a family, if and this is just in general practice, and reconnecting the child with a family, after not having a connection. So those are things that have been tried, and starting earlier, starting some type of reintegration plan earlier, and not just before the child ages out. And then keeping a connection with family, and someone who will be part of their life, after they age out of care. So these are all things that prior to there's federal support, and there's also more recognition of aging out, and supporting them for years afterwards now.
Thank you very much. I don't have any further questions, and guess I will turn it over to the next questioner. Thanks very much, guys.
All right. So I believe next would be the Innu Nation to bring their question in. And I know, Judith, you mentioned that you expect to be about 45 minutes to an hour. So just before I allow you to start, I'll just ask if there's anybody who has any quick questions, who would like to bring one. Okay.
I mean, I have a quick question, but I am quite happy to wait till after Innu Nation has gone and go in the regular order.
Okay, excellent. Well, we'll go to Judith first, and you can proceed with your questioning whenever you're ready, Judith.
Okay, thanks very much. I'll do my best. I'm hopeful we can get through it. I think a lot of the questions I had have been covered, but sometimes only in part or in different ways. So I'll have to just go through and collect my thoughts as we go to try to be efficient. So just to introduce myself, and actually I'm meeting Ms. Petti for the first time. It's great to meet you. My name's Judith Wright. Yeah, I'm at a firm called OKT, where I am now with my colleague Ashley Ash, who was at the Circle last week. And we provide legal representation to the Innu representative organizations in the inquiry, which is Innu Nation, as well as the two First Nations, Shayushu Innu First Nation and Musho Innu First Nation. And we also represent the Innu Roundtable Secretariat, so we represent them all jointly. Just want to say thanks very much for your report and all the evidence you've given today. My questions, like a lot of the other questions today, I'm going to focus in on potential recommendations that flow from what you found in looking at the lives and deaths of these 6 Innu young people. I'm not going to follow the exact order in the report page by page, so it may feel like I'm jumping around, but I'll try to follow an order that I think will help us be efficient overall. But I will start with the first theme, the colonial legacy of intergenerational trauma. So we've talked a bit about that theme today, and you did talk a bit about recommendations that flow from that. And Mr. Richard, you talked about, learning and reflecting, that it's about a process of learning and reflecting, if I have that right. And I just wanted to ask a little bit more about who needs to learn and reflect, and how can that be done? I mean, you gave the example of this inquiry being one example. but what could be some other examples of that you might recommend? Oh, you're on mute.
The dog. Most systems that are engaged in Innu life that come from the settler need work. We had occasion, met with the Labrador Correctional Center, for example. They're only beginning to appreciate, and we spoke to some very caring individuals there, but they're only themselves getting to the point where they're able to critically assess how they've been helpful or not helpful in relation to correction services with respect to the incarcerated. And there's lots of incarcerated, as you well know. So it's a big deal. We have managed to create, though, a process of moving forward, and I operate on a kind of, relationships need to be created, visions need to be, reflected on. But at the end of the day, there's some action required to realize what you want to do, back to the vision. So that's sort of what we call movement. That is been now charted in terms of how one does that. And how one does that is under the broad banner of reconciliation. And this inquiry, just to place it in my understanding of reconciliation, is a part of the truth-telling process. And I think we'll have achieved that. But what is further required is taking that truth. And the commissioner's report will do this, I hope, acknowledge what went on, and in that acknowledgement, undertake some kind of effort to address that and take ownership and accountability. But the other two components of this reconciliation process, and this comes from my work at First Nations Caring Society and how we've done it in child welfare generally, is the restoration process, where you don't necessarily walk out of the room like everybody wants to do. I know, and let me be somewhat humorous but sad at the same time. Who wants this? Well, nobody. Which government? It's about who. We know all the machinations associated with who wants to take authority, but everybody's been involved. So getting all folks at the table to talk about the restorative process, and it's not devolution; it's restoration. And that's where child welfare needs to go. And at the end of it all is a new relationship between, and I hate the word settler, but I can't find a better one, and the Innu, so that and at the end of the day, with the child at the center of the fire. And can I do my poem? It's just brief. The poem is this. The child is sacred. The child is at the center of the fire. The family keeps the fire, and the fire is on the land. So if we follow that tenet, and move in that direction, that's to me reconciliation and child welfare. So I'm not even sure what your question was, Judith, but that's my answer.
Thank you.
Yeah, I would just add, and well, first of all, agree with Ken, and I do really like his poem. It's very succinct, and but the education of the history and the colonial history is imperative in the province. I don't in my experience and my exposure to the Newfoundland culture, there is a lack of knowledge of the Indigenous history, the nations that encompass that, but I think that there is some approaches and steps to reconcile that now. But generally, and this is systemic, and there isn't knowledge, so how do we inform, the justice system, the health system, the child welfare system, in a way that helps them understand that not only the history, the systems part in it, and and how how it laid out for both sides, the advantages and disadvantages, privilege, and things like that. That's all very important, and how is that being implemented across the province, and then the healing of that. We talk about communication between the system and the families, as being a gap, but also the families in their own journey of healing and their own their own impacts from the colonial legacy that existed in their ability to have a family, to live, and to be a parent, and to work or to live on the land. Those are all things that need some elements of reconciliation. And just reconciliation involves personal healing, and that is and understanding, and that needs to be felt across. It's not just the First Nations people that need to heal and but there's also non-Indigenous people and settlers and newcomers even, that what do they know about the First Nations culture or the Innu history in Newfoundland. So those are all again efforts. They're well documented. There's lots of recommendations out there that TRC, the MMIWG inquiry, and even some of the inquiries and research and documents that have been done in Newfoundland.
Thank you. Okay, I'm going to move now to the topic of what isn't yet, or that you thought isn't, but could be or should be available in Labrador before the need, before a care placement arises, or the need for that care placement arises. So in today's evidence, you've talked, I think you've hit most of the notes I was going to ask you about. So I'll just mention some of the things that I heard come up today. Early screening for developmental, learning, cognitive, or psychiatric issues, follow-up and professional help with those issues if someone is screened in, taking into account an Innu traditional approach as well as the kind of best of the West approach that you mentioned, collaborating with other service providers like schools and others, youth mental health, addictions, treatment, counseling programs for those with more advanced needs that provide ongoing support, on a kind of, as you said, a clinic, or, kind of access is there. You also mentioned positive programming for children and youth, like after school or summer camps, and, mentoring, kind of, as you said, that kind of like old school youth work, and support for parents. And you mentioned land-based, of course, and culture. That really did cover my list, and I think everything came up. Is there anything else that you might want to mention about, from your experience and from what both from your experience and from what you saw in the cases, that you would want to see available in Labrador to prevent cases like these from playing out the way they did?
The only thing I want to add to that extensive list is the need, and this is actually my training, is for community development to be undertaken such that we strengthen what's already there. And what's already there is a strong sense that everybody is responsible for everybody else's kids, that it's a collective process. That is lost in many communities, and it's probably has been significantly diminished because of the realities of colonization for the Innu, but establishing the ethic of community responsibility to everybody else's kids, including your, not just your own, goes a long way in terms of, for example, like gas sniffing. You see, there's a child sniffing, and you go, oh, I'm going to talk to their parents, because it's that kind of simple stuff that I think in other generations took for granted but have been lost, And the revitalization of a community, acting as community. And I know they do it because I've been to the gathering. You know, I've been to places where it's very evident that they see themselves as a collective. So to build that in with good community development, into engagement on the issues confronting youth, is probably what is also missing in addition to all that list of services that you just put forward.
Yeah. And the only thing that I would have to add is, I talked a lot about, educating mainstream people about the history and the impacts. But in this scenario, in this question, I also believe that there needs to be a knowledge, with the Innu people, and of what are what mainstream services are there, and how can they benefit, because sometimes you need them, like people need to go to the hospital to get services. Maybe there might be very specific mental health needs, that can be serviced, by a mental health system. And in fact, in one of our families, there was evidence of that. There was someone whose adult child was in a kind of an institutionalized setting, and they worked with with the mental health system. So there was knowledge, there is services that people are and they have an understanding of why these services are needed. But is that the first response? Is that the first service that's needed? It's that shift, and knowing when those services are essential or needed, and when community revitalization and support is more the emphasis.
Thank you. I'm just looking for a minute at my notes to see what I need to cover from this next part. Hold on a second. Okay, so I'll move now to talking about the Child and Family Services system, including child protection services, but not only. And I'll just note that, Innu Prevention Services does exist now. It's growing, but it only came into existence towards the end of the time period that you were looking at in your investigations. You did give a lot of examples earlier about, what, prevention can look like, early prevention, secondary prevention, tertiary, you gave some of these examples. So I'm not going to, I don't think we need to talk more about that. But, well, maybe I'll just ask if there's anything else you wanted to add about, you did speak about those before, but if there's anything you wanted to add about services, there's so much that was missing, of course, before, which we've touched on, but if there's anything else you wanted to add about where you would want to see prevention services grow or expand into, in particular, I'll just offer that up.
I just always want to reinforce that sometimes we get almost intoxicated by the note, and I'm talking about the Indigenous sector, by the notions that once we control it, it'll all be good. Well, there's still going to be kids that are going to be in extreme distress. And the kids we looked at they were moving into full-blown psychosis, and a couple of them were already there. And, hockey, like earlier comments, they're not going to play hockey. So never lose sight of the special needs kids, because they can be easily forgotten. And those are the ones that are sniffing gas and expressing suicide ideation. And and accept that 1 out of 10 of kids are going to be special needs, and they need to be planned for. And that's where collaboration with the best of the West, and including medication possibly. It was badly handled in these reviews, but there's been tremendous advances in medication that, will prevent kids from being in the kind of distress these kids were in. But we got a long way to go to that one because of what's already built into in terms of misunderstanding and lack of trust on medication. But that stuff's going to need to be worked on. And yeah. And there's also, by the way, other kinds of medication. There's on the land stuff too. So, yeah, I don't know where I'm going now, so I'll say Tara.
Yeah. The only thing that I can add to that is, also, an understanding of the impacts, of, of the history, and the treatment of systems towards Innu people. And like Ken said, then when we are now in a position to say, the Innu people, the Innu nation will manage their own, there needs to be recognition, that that there has been harm and everyone's been impacted by it. And that they, that even in the development of systems, in the development or the, transformation, they're also, it needs to go hand in hand with, individual and nation based, healing and connection and restoring those, the trust in each other, and family, families and opportunities. We're still dealing with, poverty, housing, basic needs. And then we're saying, now you can take over your child welfare system. So really doing things in an incremental way, that doesn't already kind of overload or cause, additional stress to already stressful situations.
Yeah. Thanks for that advice. That's helpful. And you did already touch, moving into kind of CSSD, you talked about, the structural instability they faced. I mean, that's in your report, their staffing shortages, turnover, and the issues with the rotational workforce model. Catherine had asked you about recommendations related to that earlier. And you did talk about, building Innu staff over the long term, thinking about how you can use more Innu staff in the picture over the short term. Just wanted to ask if there's anything else around that or any best practices that you've seen, as has come up. I mean, turnover and staffing are big issues in the child welfare sector all over, but I'm sure there are, that said, it's not without people having given it attention too, right? So I'm wondering if there are any, stories you can share or practices you can share that have been useful.
I don't know of a lot of successes actually on this. It's a problem that is national, north, south, east, west, particularly when you talk about servicing. I mean, those of us who have spent time in the community know it's not easy. You're a stranger there for sure. There's no accommodation. The food's, it's ridiculously expensive, out of control, and it's not your world, and you're choking on dust half the time. It's the secret is to move forward on that development of Innu provided care. How to get it takes a certain kind of social worker to be able to manage. We met a couple in our travels, to be able to go there and like being there, notwithstanding all the issues. And that's where you need to go. And I don't want to be stupid and say, well, if you paid them more, they'd come. But if you did, they would. It's there's they're not very well supported when they're there. They're living in a trailer. There's no place to do counseling. There's it's their lives in a goldfish bowl as well. So it's just there's so many things mitigating that. So that's where you do your own consultation, the Innu Nation, maybe on something like that, how to retain what's wrong and how to correct it.
So in my experience and work experience, I have worked as a First Nations social worker in a First Nations agency, which was also the community where I'm from. So like to me, like there, that was I don't know, like a best practice in terms of being under, working in the system. But we couldn't change the system. Uh, but what I can recall, during the time, like there were opportunities, for our in the Manitoba system, there were opportunities for First Nation, Métis, Indigenous social workers, to get an education while still being in the community or still being in practice. There were there were opportunities, whether it was through a certificate program that was recognized, then at a university level or from a university program. I'm not saying that they were all functional and well done, but there were opportunities there, and there was movement, in the kind of in the institutions, the education institutions to start, delivering their programming differently. And I see that kind of spreading, more west. You see a lot of that in Saskatchewan and Alberta, where there's more, in the education of social workers, that there's more cultural involvement and participation of elders, things like that. So that, to me was a very strengthening experience as an Indigenous social worker in kind of a mainstream system. So looking at, how do we educate, our, uh, uh, our own people to work in our own system. And then, income and, including, very definite, uh, practices of self reflection, healing, um, wrapping around when it is a difficult situation, how do we debrief, things like that, are there's lots more that I'm just thinking, just in my experience, but we're with the opportunities, because of the Human Rights Tribunal, the National Human Rights Tribunal, and the the things that are coming out of that. There's a huge amount of like evidence and best practices and things that people we can take some time to digest and explore and use. So I believe that today the First Nations, including Nations, are have shared their experiences. There's literature, there's advocacy, and it just grow along with it.
Yeah. Thank you. In your report, you talk about the kind of narrow orientation of the child protection system, being kind of narrowly focused, reactive to full-blown problems, and forensic, focused on kind of investigating problems, as well as that, child, at least in the time you were looking at it, child removal too often was the first option. Can you describe to us, I mean, it may seem obvious in describing that, but in some ways it's not. And if you could describe to us a bit more directly, what should this look like differently?
Yeah, well, it has to be a system that is differently conceived from the outset. And what I mean by that is, uh, uh, for example, you can build a children's aid society or a child protection agency that has services that would enhance the protection function, which is what people often try to do. Or you can build a holistic agency focused on child and family well-being that has as part of its services child protection, and that looks quite different because it's not led by the forensic model. It's led by another model, and that is the child and family well-being model, which looks more at strengths and how to work with the strengths of a given family. And, that's rarely something that's attended to in a child welfare investigation. Child welfare investigations, from the forensic perspective, involves going in and confirming that the complaint is valid, because it's often complaint driven, or it's often at the end of people's rope, so it's a different kind of narrative. So to divorce yourself from that mindset, never losing track. And I always have to say this, because some people say, oh, well, you're minimizing the need for child protection. My experience, which is extensive, most kids are not in jeopardy in their homes, immediate jeopardy where they need to be removed. That happens, and I've done that. But mostly what we're dealing with is folks who are distressed, overwhelmed. They're, yes, neglecting their kids from the perspective of legislation, but at the same time, they're nurturing them in different ways. I haven't met any kids that want to be taken into care. Very few, except for the odd teenager that is in conflict with their parents. And those of us who have raised kids know that sometimes they don't want to be here. But I've not met too many kids at all that ever, even in the most difficult scenarios, that have actually wanted to be removed. So that's your first indicator that we need a new model. So that model should shift away to one that is inclusive, holistic, culturally based, accountable, and appropriately resourced. Um, the forensic model hasn't worked. It needs to be jettisoned as quickly as we possibly can without jeopardizing safety. And that's always a challenge in certain situations.
Mhm. Well, Ken and I talked about this several times, over the course of our investigations. Is how do you manage, the balance between child protection and kind of family preservation, and the growth of, more, healthy family systems, well-being, those kinds of areas, because there's always going to be a need for child protection in any system. There's going to be a scenario where where a child needs protection, and then how do you kind of recover from that, from that initial response, which might be a removal. Then how do you build the back, the trauma of the removal, and the preservation of the family and the healing of the family, so that they can reconnect, because they will eventually. And so it is an area that is very difficult to navigate, and I believe it is very community specific, and we do need to hear from the community on what does it mean to protect children. I can look back into some of my very earlier practice on reserve, and we would sometimes if we knew that there was like, say, something happening in a home, like a party or something, and grandma could take care of the child until the parents were ready to take their children back. And we would facilitate those arrangements for a weekend, or things, and help grandma with the babysitting. And there was kind of an understanding, but that was something that wasn't allowed. So and we need to be able to look at the kind of those kind of natural systems. We're not dealing with some of the substances and things that that the issues that are exist today, but but really looking at at things differently, but acknowledging that there is a need to protect children in situations, and then kind of again, like, how do we recover from that and move forward in the interests of and well-being of the children and the family and the community.
So I, up until when I was the director there at Native Child, would often get problems brought to my desk. For example, to make it real tangible, this is real. A young boy at his grandmother's, sleeping on the couch with a grandmother who, her past history was questionable. When she was younger, she was addicted and had all the problems. So she had her own file, you know. And my workers saying, well, you know, the rules say, well, because grandma's had this history that she's not an appropriate caregiver, she wouldn't get a license. And the boy sleeping on a couch, and we know that the standards are are not being met. Sleeping on a couch, the standards require so many things, including window size and your own bed and all that. So, so the plan was to move, let's call him Johnny, to from his grandmother's place in the east end of Toronto to Oshawa, to a properly licensed home with his own room and everything. And that was what the system wanted us to do, was compelling us to do with respect to standards. And what do you think we did? He stayed with Granny, but we were breaking the rules in doing that. And that's the dilemma faced on a daily basis with this existing model, is it prevents actually the kind of culture-based approach to child welfare that everybody aspires to.
Mhm. Yeah. And that was evident in our investigations, you know, where you know, parents spoke of, you know, recommending family members, you know, to care for their children. And it's very natural. You know, there's still a very collective responsibility of children. And that was evident, you know, in our, you know, but there was also issues, you know, families had issues, you know, with alcoholism and, you know, different, you know, things from having experienced lots of trauma. But so back to, you know, so when the parents would recommend, oh, my sister or my cousin, or, you know, and they wouldn't pass the checks, you know, of CSSD, you know, the background checks or the, you know, whatever, you know, so they were disqualified. But were they really, you know, and had, you know, what is the lens on that? And how can you support, you know, an overcrowded home, you know, or, you know, people new in their recovery, you know, and taking on, you know, the care of their family members and things like that. So it goes beyond, you know, you can't have the expectation that, you know, everyone is going to be, you know, perfectly able and capable. You know, we have to support these family placements as well, you know, financially, and also, you know, in, you know, I don't want to say therapeutic, but in, you know, in a way that, you know, still, you know, helps them succeed as caregivers, and the value that they can bring to keeping their family members.
But to conclude, you know, sometimes you actually have to go against the standards to actually remain true to the Indigenous approach. All that, so there's a lot on these workers, Indigenous workers, for sure, you know, and that has to be built into this developmental process that I'm talking about.
And what I hear when you say sometimes you know, have to break the standards is essentially, if I may paraphrase, like sometimes you need the flexibility to override the standards when it's in the best interest of a child, like to focus on the true best interest versus the standard.
Exactly. Because if best interest is the overriding principle, and if the standard doesn't support best, I'm just repeating what you just said, but yeah, I 100% agree with you.
Okay. I'm going to move on to the topic of disempowerment related specifically to youth. And I mean, you've given some examples, you know, I'll try not to repeat them all, right? But just, you know, just to remind ourselves what we're talking about, but, you know, youth who were, you know, things were not really explained to them. They weren't consulted, they weren't engaged, and their, you know, their input was often not obtained, let alone their consent. Sometimes they didn't know where they were going. They weren't treated as active participants in their own care. And again, I'd like you to paint the picture for me of what that should look like differently with the youth, the children, and children. Some are older children, right? With older children or youth, and we can be flexible here about what that means. Sure. If you can paint that picture for us a bit.
I mean, when you're talking, I'm flashing on a particular kid that you know, not only was he disempowered, he was misled, and and I think it was to get him on the plane. They said, if you go to this place, you'll be there for 30 days and then he'll come back. Well, that was a misrepresentation altogether and an ethical breach there. Although our job wasn't to flag those per se in the same way. From that, that's a long way from establishing a relationship with a boy. In this case, it was a boy, such that he was party to his own proceedings, his own service delivery. And that's the challenge. None of these, well, I don't want to say none of them. I'm not saying they all had bad relationships. I, in truth, have to go on what I've been told that some of these relationships are actually pretty good. Um, but it's very clear that um, the boys were not, and the one girl were not sufficiently versed in uh, what system they were engaged with so that they understood a baseline understanding, that were primarily reacting in survival mode and hypervigilance. They were distressed. They had onset mental health distress writ large, who's like, early onset schizophrenia. You know, how it was a real challenge for them to understand what was going on, and a challenge on the part of the social workers to convey it. Social workers who were run ragged, didn't have a lot of time with the kids, were doing this stuff 90% of the time on the bloody phone. You know, it seems impossible, and it was. So systemically, the kids were disempowered. There was rarely when the social workers deliberately, except for what I've just flagged in my evidence anyway, where they were just deliberately disempowered. But the system worked such that it was one of the products of the engagement process. I don't know. I don't know if I've been clear. Tara, maybe you can be clearer than that.
Oh, you're on mute, Tara.
Sorry, now my dog is bugging me. But the disempowerment of youth was directly related to the disempowerment of their family. So and that had to do with a family kind of giving up their power in terms of, again, a lot of the situations that we looked at. The families came to the agency because they just didn't know what else to do, and it was that action that then gave them the impression that they've lost they've lost their child and they don't have a say anymore. So how is so if you and then so when we look at communication that they might have had with their children, there was disempowerment there. They were monitored. It was a certain time. They couldn't speak Innu. And if there was complaints, if the child said, oh, this is happening to me, in one situation, like, my foster parent makes me put their socks on for them, and what was the recourse of that? How could that be brought, there wasn't anything that the parents felt that they could do to change that for their child. Or if they did, it wasn't addressed and they didn't know if it was addressed. So those are all kind of related to the themes of, communication, maybe staff turnover, different different levels of, where the family was at, in terms of, their healing, their, working within, any issues they may have had, and and then even just the feeling of, not being able to care for their child. Like we talked to one parent who said, in the end, I just gave up, because everything that the workers gave me made me feel like a bad parent, and that I couldn't look after my own child. And another parent said, I needed to heal, and the only way I could do that was just to leave and go and build a tent in the bush and heal myself. So there isn't often grace given for that, and then the system doesn't forgive. A parent could be totally healed and sober and, able to look after other children, but they still won't get those other children back that they lost when they were in the, in the depth of their, their trauma and, the relief that they were trying to achieve, with the, the behaviors of addiction.
Thank you. I'm just looking through my notes just to give me a second, just to make sure. I don't want to repeat things that you've covered. In terms of the reliance on out-of-province placements, which you've noted has occurred in, 5 out of the 6 cases. You talked about that, a prolonged separation caused significant cultural harm as well as emotional trauma. And you talked about, there's harm in that, right? There's harm in using a placement that is away like that. And I have a couple of questions related to this, but one is, how can the system kind of better account for this in decision making, in thinking about different options? I mean, a system, I presume, is looking at options that exist, that are available. And as you said, as Ken said earlier, they made beds available, but how can these risks be better taken into account?
I think this speaks to, voluntary versus involuntary, types of placements, based on the safety of the children.
Yeah.
And I guess the capacity, for the system, to address, situations where it may have to be involuntary, especially for youth, like, and that would be kind of like the, the crux of, like a really, inability, to control, behaviors, such as the gas sniffing and, things like that, coupled with, potential, mental health, the impacts that it's causing on their mental health. The behaviors are, to escape pain, right? And if they can't describe their pain, how can they heal? And so, so what we saw was, bringing a child into care then made, made the system to be able to make decisions that were involuntary, and there were not really many resources in the province, to facilitate that, whether if it's temporary or long-term, crisis management. So that, that was, was, for one thing, it's difficult to manage that as a system, and, do we have crisis stabilization units? Do we have, kind of, in the moment, care or counseling or therapeutic resources? And then, in what we saw is there wasn't much options. If youth wanted treatment, or the families came because of treatment of an addiction to solvents or alcohol or marijuana or whatever, that all of those things were voluntary. So you could, a social worker could, or someone from the healing center, like a NADAP worker, could facilitate, a treatment center. But if the youth said, no, I don't want to be here anymore, then they got sent home, and that was, that is something that, is difficult to manage and to navigate.
Yeah. So I'm going to be frank here. There was some resources there was the healing center. There was the Charles J. Andrew as well in Goose Bay. They were immediate, that sort of had some responsibility in these cases, but they were not able to. They were at different stages of their own development. The Healing Lodge had an ex-cop, as far as I know, with no clinical work experience. We met him, nice fella, but he would not be sufficiently trained to, even case manage the mental health components of a kid who is an early onset schizophrenia, which a couple of these kids were. Charles J. Andrew, it seems their mandate was shifting. People didn't seem to have consider them very often as party to work with these kids. You also had on the island Janeway, you had Hope Valley, you had a third one that I can't recall. None of them did any Innu work, really. The Innu were foreigners to them. They didn't have a program. In fact, one of the Sibs visited her brother at Hope Valley and said it felt like a jail to her. So, you know, the Newfoundland system just was a fail from without even many attempts to actually utilize it, which is kind of sad because those organizations had a responsibility to serve all Newfoundland Labradorians, and they didn't. The Innu were forgotten. They weren't in the picture. They weren't in the consideration, seemingly. So I know that's changed, but at that time, that was the case. So the only options were out of province placement, and I understand that. And they had also the beds, no waiting list, no everything. These kids were precipitous in terms of their own self destruction. I would have probably made the same decisions, notwithstanding that I would understand exactly what I was doing. I was protecting the child at the cost of cultural safety, as one of the social workers put it. And yeah.
And then having to bring them into care, to
Yeah,
access.
well, sometimes bringing them into care to do that. And they didn't use NADAP. Well, there's a couple of efforts. One of the kids went to Thunder Bay. Another kid went somewhere in Ontario to programs I'm not that familiar with, but none of them worked. Particularly out of province where they ended up. It was easy to criticize, but let's also reflect on Newfoundland's failure, with all due respect, to mandate their own children's mental health services to get literate in terms of service to Innu people.
Okay, thank you. I'm going to move into the topic. So we're in terms of when Innu children are in a placement, and this could be in or out of province. But you've talked today and in the report about how these were youth who needed therapeutic services, and while some of the placements promoted themselves as providing treatment, generally they didn't really. And I wanted to ask about, how can that be better avoided in the future? For example, what kinds of questions should a child protection service provider be asking about therapy or treatment? And, what other kinds of accountability could assist with this?
So the treatment centers in Ontario told us that they were, BARTS, for example, rested their treatment program on the fact that they had a consulting psychologist that they utilized, and that they, on the cultural side of things, so for the mental health, on the cultural side of things, had a relationship with an elder. So, entirely superficial, that relationship with an elder. When it comes to an Innu kid, a relationship with an elder from the Anishinaabe way, and that's all good for the Anishinaabe, but not so good for an Innu boy or girl. So that they're just the question I would be asking is, tell me more about what you have to offer. What is your understanding of the context of this child that we're referring? And if you don't know, we'll help you. I would be asking them to be explicit about their service model. Uh, and what I mean by that is, give me the values, the give me the knowledge base that you have with respect to that, like who's trained, who's not. Give me your best practices as they reflect the needs of Indigenous youth. So those questions um, will give you kind of a good picture, but specific to, any one of these kids, there would be particular questions associated with each child with respect to their needs. Um, the girl was very different from her needs from um, a couple of the boys. One of the boys was clearly developmentally handicapped and or cognitively delayed or whatever the language is these days. And so he was placed in a place that didn't really acknowledge that. Um, so I would really get general questions around their understanding and capacity to serve Indigenous people per se, and specific questions associated with the needs of that child. And that is quite different from what happened. What happened was they phoned, you got a bed, we got a kid that he's suicidally ideating, is that a word? Um, and let's get him on the plane as quickly as possible before we have another death in the community. That's more or less the referral process without that many questions.
Can you just kind of phrase the question? I just got.
No problem. I was just asking how, I was noting that you had observed that a number of the placements purported to offer treatment, but did not really. And I was asking if you have any recommendations about how that type of situation can be avoided in the future, in terms of, as you put it, as Ken put it, a referral process, thinking about that, or other lines of accountability, whatever recommendations come to your mind around that.
Yeah, the treatment resources, the out of province treatment resources that we got to know, so like Quinte, Bart's, and Ranch Erlo, they did have a very like a clinical model of treatment, that they operated their organization around. And particularly Ranch Erlo, they're situated in Saskatchewan, and they have made like great efforts, to incorporate, the more cultural exposure and involvement, with their staff, but also with those accessing treatment resources there. And it's kind of like a blend of resources. It's not just Jordan House, and it's not, they have different and they also serve different age groups, even adults. So and that's very evident, in their in their models, and their annual reports and their program development. So that but it's so anyone referring a child there, would need to know that, and you would also need to know you're sending this child to Saskatchewan. They're not going to get exposure to language. They're not going to get Innu culture or food or, or the land experience, so that needed to be very carefully paid attention to, I guess, in the case management or case planning process, which, again, was, very fragmented. So, so that is and then there isn't in, locally, really anything, we have the kind of the development of the Shishishi group home, there's different things happening, but it wasn't happening at a pace that, met the needs of the crises that we experienced. And I often thought of, like in our practice, in my practice, like we had access, even though it wasn't First Nations led or delivered, we did have access to crisis stabilization units, mobile, mobile crisis support, um, and and it was, and even placements, that were temporary, just for a number of days, just so we can get, the crisis, the person stabilized in a, in a state of mental health where they can cooperate or make a decision, or, come to some, so and those things, we didn't see, in our investigation. So, developing that, so.
Notwithstanding their articulation of service models, it was mostly behavioral management that was at play, and a naive belief that structure and containment and rewards and punishments were the right way. And that's, behavioral therapy. I understand that, and that can be deemed to be treatment. But it did not accommodate within that service system a lot of what these kids were bringing, not just their Innu culture, but their mental state, which was not really about behavioral management, although that was required. It was about a lot more in-depth psychiatric, Western, best of the West stuff, in addition to authentic, which they didn't have, including Ranch Elro. I don't want to brag too much about them because they're focused on their local community, and that's great because the Dakota, the Cree, the Soto, they're all around there and they need to be acknowledged. But the Innu kids were kind of an afterthought. So I would ask those hard questions, um, yeah. But they weren't. As I said, it was a panic response. It was crisis driven. Good social work, best practices that we're talking about right now were not really possible given the extent of the need and the emergence of, case critical in terms of a potential death. Fear ruled. When fear rules the social work process, you make expedient decisions, which at the end of the day you might regret, but at least the kids didn't die then. Unfortunately, they died later.
All right, everybody. That would conclude the third portion of Kenn and Tara's testimony. We'll take a quick 5-minute break here now, and we'll come back at 3 p.m. Newfoundland time, where we will watch the final 29 minutes of Kenn and Tara's testimony. Thank you.
Thank you.
Welcome back, everybody. Now that we've returned from our little health break, we will continue with the final portion of Ken and Tara's testimony. This portion will be approximately 29 minutes, after which time the commissioners, if they have questions for Ken and Tara, will put their questions to them. Thank you. So we'll go ahead with the video now. Will, were you able to get your meeting pushed?
Yeah, I'm good.
Okay, all right.
I'm also out of breath because I've been running for the last 5 minutes. But yeah, no, we're good.
Okay, so we'll resume with Judith, and then when she concludes, we'll go to you for your questions.
Thank you.
Thank you.
Okay, sounds good. I won't be too much longer. I want to talk about the Labrador group home. So at the top of page 11, you mention a group home. In the report, it doesn't identify the group home that, you know, in your findings had a lack of clinical a lack of oversight of clinical standards, issues with safety and with compliance. And I just wanted to confirm, just for the record, that this was not it's not the one of the Innu group homes. There's now 2 Innu group homes running. This was a different group home in Labrador.
That it was the Labrador group home, like that's what it was called.
That's what it was called, which is not an Innu run group
No,
home.
no, it was a group home that was managed by the provincial government. As I mentioned, it was also in transition, you know, so it had been a resource under the corrections system or the justice system that then transferred to the child welfare system. So the operation during the time of our investigation was still in that transition.
Okay, thanks. And so my more substantive question about it, you know, because your findings about it are troubling. It's that not only was there non-compliance, you know, a lot of issues there, not meeting standards, lack of planning, lack of training, and so on, but that the non-compliance persisted without enforcement. And I wanted to ask, you know, what do you think can be done about that? Or I guess to start off with, why do you think the province didn't enforce its rules with this group home? And I guess moving beyond that, the question is, what do you think can be done to create more accountability in a situation like that going forward?
Well, I guess the licensing and oversight of a group home, you know, is a responsibility of the mandating body or the province, you know, because it generally involves some type of like a core funding, you know, so it's as opposed to like a specialized group home or a specialized foster home where it's kind of still per diem based. So this is per diem based, but there's also some type of a grant or some type of a core funding that, you know, that stabilizes the you know, the activities of the organization. And so with that funding comes, you know, an agreement, you know, service agreement. These are the services that you'll provide, and here's the rules you will follow. So we, you know, what we understood as investigators is that was transitioning, you know, so there was different rules in the correction system, and there was you know, there was kind of an agreement on the interim until they could become fully licensed. And then during that agreement time, there was CSSD officials, you know, who then were responsible for monitoring the home, like in terms of, you know, they had a checklist, you know, and then there was also other investigations in the home that were ongoing, or at least one significant investigation about an incident. And so in our review, you know, our question also was, well, how come, like, who monitored the monitoring, you know, like, and when, you know, and in any recommendations, we're kind of answered with, lack of resources on the group home side, and you need to, negotiate with the government, like, an understanding of the resources needed. So it just seemed like this, iterative cycle that just did not resolve itself, despite, a major incident in the home, even prior to, the child taking his life in the home. And then afterwards, the, I guess, the cleanup of the home, for lack of a better word, and then understanding now, what is the conditions of the home? Is it, and what I understand now is that there is some type of a clinical resource that is available to them, to provide kind of the clinical guidance of the home, but that wasn't in existence before. And it just kind of seemed to be a toss up between the child welfare system and then the behavior of the group home, and there didn't seem to be anything above that, in the governance of, these systems, where it's a board of directors, or, at more of a deputy minister or an assistant deputy minister or director level, to, provide any, any type of, this is what you need to do, compliance related. And so it just kind of languished, and it just developed into, what we called a regulatory drift, where there wasn't really any adherence to things, but there was knowledge that there was lack of adherence to, whether it's the service agreement or the legislation governing child welfare, or the the board, vision, mission, goal, like those are all things where we couldn't see above who we spoke to, and having, a little bit more, I guess, breadth in, speaking to, higher levels, wasn't an opportunity that we had.
Oh, you're on mute, Ken. But it looks important.
I'm going to be a little more emphatic than that. They were, notwithstanding they were in transition, that's polite. They were a level 4 home. And as being a level 4 home, they had responsibilities to be compliant to the standards associated with that. And CSSD fulfilled their obligation in terms of evaluating that. And it was a monthly check-in with respect to standards. And there was a consistent non-compliance, as Tara mentioned. CSD seemed to tolerate that non-compliance. And as far as we can see, there was no urgency that was felt at the Labrador group home to comply. That mostly in the conversation they talked about, well, we didn't have the funds to do this and that. We never spoke to the bosses, the check signers for the Labrador group home, who were responsible for that transition. We had one meeting with CSSD where they couldn't explain why they didn't order something to happen, given the non-compliance and the risk associated with that. And this particular one was made even more alarming, that we didn't have an opportunity to really even talk to the folks who were in charge. And the folks that were in charge were a 3-person board made up of the good citizens of Goose Bay, and somehow nobody could reach them. So it was a bit of a distressing element to the investigation process. So I just want to be frank about that. This child that died in that facility, child who lived in that facility had suicide. He was predicting his death, and they didn't know what to do with it because they didn't have sufficient resources or expertise to manage a kid in that kind of distress. And it is actually happened. And we heard actually in our investigations that the situation hadn't changed much, which caused in the middle of a circle the CSD to go over and check it out and come back to the circle and reassure the circle. Will, you were there, that things were okay. But, you know, it's a pretty alarming scenario, that one. And it raises so many other questions that we'll leave to the inquiry because it's out of our scope, I guess.
Okay. Okay, the last topic I'll ask about is the topic of reintegration, aging out, aftercare. It's a huge topic, but you have talked about it earlier today. And I just want to focus in. I mean, you've been very clear about what wasn't there for these youth, which pretty much nothing was there for them in terms of this. But I want to just talk differently about what should be there, or what should have been there, what could be there. So I mean, I'll just put, maybe just to help move us along in terms of time, I'll just put some suggestions or examples forward, and I'd like to get your take on them. You mentioned earlier a transition plan, you know, starting early in those discussions involving the family. You mentioned the need for someone to be responsible as a first step. There needs to be a kind of lead agency or responsible person, which there wasn't necessarily a mandate, you know, as it came up as in a question, I guess, as well. And then in terms of kind of the substance of it, you know, that hasn't really come up today a little bit, but it's mentioned a little bit in your report in terms of what wasn't there. Supports like housing if needed, you know, potentially life skills, work with the family. I believe it came up in one of the circles that, you know, that could potentially involve circles with the youth and their family or other relationships, other people they are in relationship with. Yeah, go ahead. So I'm just listing some examples of here. I'll just mention a couple more, you know, things like income, basic needs, education support, transition to employment, guidance, mentoring, case management, and of course, things like therapy, counseling, mental health, access to treatment. Do you agree with that list? Do you have others that you might want to suggest?
I agree with that list.
I agree with the list, and I could suggest quickly that you know, there are now like in child welfare agencies, there's kind of dedicated units, you know, to transitioning out of care, and they're separate, you know, from, you know, the prevention and protection and, you know, other areas of our departments within an agency. Kind of a model, you know, a model of, you know, what does turning into an adult mean, you know, in when you're in care or when you're receiving supports, and that maybe, you know, is available to everybody, not just, you know, being warranted by being in care, but that is, you know, community driven preparation to, you know, entering into this life stage.
Oh, you're on mute. The old mute.
Here I am. My belief is that every child has their own time when they age out. Some kids have to be cared for consistently for well beyond the typical expiration date of their time in care. I see this as a moral obligation of the state, in this case the province, to treat them, their role as similar to caring for their own children personally. Yeah, you know, I guess some people kick their kids out. I got a 34-year-old living upstairs here that I'd like to kick out on occasion, but you know, it's like that. It's that if you say, I'm taking you out of your home, you have a moral obligation, and my, notwithstanding whatever else is said, to do better and to be the best parent possible. And the system generally, Newfoundland included, has not seen that moral obligation quite the same way.
Okay, and just one last question for me is just the other. Do you have Do you have any other recommendations in particular, you know, that haven't been touched on yet?
It's a long game. It has to be understood that there's not a magic bullet. And when I don't know if this is a recommendation or more so a reflection, you know, we've seen a lot of stumbling around now. The lawyers are writing the law, the communities are coalescing around the law and everything, and then they're starting to see certain realities. Tara and I worked with the community in the West there that, you know, had it all. But what they didn't have was they were ill prepared to deal with the reality of some of the difficult cases that would come before them. And so to be able to go slowly, appreciate that it's a developmental process, not a get the law, get the you know the funding and it's all good. It's a painstaking process of development, trial and error, and that the child is always at the center of it. And that's sometimes hard to reconcile with other competing realities with First Nations. But when it comes to child welfare, that's all. You know, if there's not one person or one agency that understands that, then kids are not safe. So yeah, long game, collaborative, appreciating what each brings to the table, because the West brings stuff to the table, the Innu bring their own stuff to the table. Within that is a third developmental process that is fueled by that knowledge base that both bring. And yeah, the problem is though, it's constrained by, there's still so much trauma. We found that in our circles. You know, people still have feelings, and why shouldn't they? So we need that reconciliation piece to it as well. So that's my comments on that.
Yeah. I mean, I could, you know, spend a lot more time reflecting on all of these reports and discovering, you know, different recommendations that can be made. But, you know, we were very aware, and, you know, that wasn't our role. So we tried to, you know, deliver our findings in a way that would lead to kind of, you know, the reflection of recommendations. But I do agree with Ken that, you know, this isn't a short-term thing. You know, when you think of the opportunities for nations right now to develop capacity and stuff, it's very time limited and funding restricted. And I think that is going to be a pattern, you know, that will, you know, manifest over the years, because it always is, you know, in terms of how do we fund this system. And then you're going to have, there's many different new systems that are emerging that are very, you know, individually, you know, funded, you know, for lack of a better word. But how is that going to look long term? So looking at it, you know, in the long run, as nation, you know, nation building and nation led, and then supported, you know, by through the, you know, rights and obligations of, you know, the different, you know, the different rights and obligations that First Nations have, you know, with in their relationship with Canada and with and you know, with the rights that they have, and what has been withheld, you know, for many generations. So we can't just box it up and say, here's how much it's going to cost, and then 5 years later say, no, it's going to be less now. But you know, to really have that you know, that long-term outcome focused well-being support.
Thank you both. That's it for me.
Thank you. We'll go now to Will.
Thank you. Good to see you, Tara and Ken. Kara, there you go. Maybe that's your joint
I've
name.
been doing that too, Will.
My wife's name is Jane, so we get Jill and Wayne occasionally. I guess you guys got the same thing going. Just wanted to ask first, I guess, whether these hearings were happening as circles or as formal investigative hearings had any impact on the way that you presented your reports, or whether that was a consideration that went into the type of report you were preparing or not.
Do you want me to start, Ken? I will.
I didn't know. I just wanted to say I didn't give that a thought, truly. So Tara might
Yeah.
have. I prepared the report that I thought reflected what we were told, and tossed it into the machine. The machine digested it, and here we are.
Hmm. Well, and I looked at the report as, an opportunity to, you know, um, do something differently, and that is really look at the systemic issues. I've dealt with lots of reports either, that I've been part of or that I've had to respond to, where it was very, the system issues were, I guess, not reflected on in a way. And it was really just looking at the individual actions, lack of compliance, and things like that. Uh, and then, as opposed to, being part of a formal hearing or a circle, the circle was, something that was, very different. And I think it, put everyone in a state of vulnerability, sitting in that circle and listening and then having to speak to it. So I think, but we didn't know that going in. We didn't know what it was going to look like. And, we, and there, there had to be some formal components to it, so that it's still part of the judicial record and, and part of the inquiry process. And I believe that, the inquiry team and all involved, navigated that very carefully and respectfully. And that is, something, to really learn from and grow from, not only in Newfoundland, but, in other jurisdictions as well.
Thank you.
Truly, you guys have done something that is a leapfrog ahead of much of the other developmental processes. And yeah, I want to congratulate. Well, I will do that more with others, but with it, it was really something for us to experience as well. So we wrote what we understood to be the truth of what we were required under the orders, and that it transpired to be a reconciliation process the way it seems to have done. And I know it's not 100% there, but that's you got something to say to the rest of Canada in terms of moving forward on this very difficult long game of child welfare transformation.
Thank you, Ken and Tara. Um, so, I know that there were certain stipulations in order to allow these healing circles to be the open experience and the sharing experience, the honest experience they were. One of those was that, we wouldn't go and take people's statements from the healing circle as we would testimony in a formal hearing.
That's right.
Was there anything that did you feel in any way constrained by that, or was that fine by you in terms of, was there anything that came out of the hearings that you felt, and I know you said earlier that the hearings very much solidified the view that you had kind of going into after doing the reports when you were going into the hearings. Was there anything you felt that you would have wished that you could quote or that was important from those hearings in that way? Or did you feel that was an okay kind of balancing?
Tara?
Well, like, the hearings themselves, were very powerful when they were done this way. So there was part of me that reflected, on, how can the power of this hearing, be documented, in a way that helps, other processes or that can be modeled. And, there's also the balance of, kind of a ceremonial type of circle, and then the kind that we were, introducing and implementing. The other thing that I noticed was, we didn't, as investigators, like we didn't always have like a lot of time, to develop a really good relationship with the families and hear. So we also heard things in the hearings that we didn't hear during our investigation process. In terms of like, people's experiences or how they felt or how they viewed, the circumstances. um, and so that was also something that was for me nice to hear, because we didn't always have the opportunity to get there with the time that we had with the families. And then particularly with the hearing about the Labrador group home, that one was so, it was so, like the family itself, this was a generational thing for them, because the father, had also been in that group home, and then having his own children in the group home was like extremely triggering for him. And, like, I don't, that was, how do we address that, in recommendations, when the family just adamantly said, we do not want that, group home to be open anymore. And then so you like, in situations where I have been, where there has been like a really collective, belief, about something, then someone in authority would make a statement. Like, so for example, like, a chief and council would say, we are not going to use this resource anymore, until, or, something that would made a statement. And so I was just wondering, like, what kind of a statement is going to be made about um, the Labrador group home and the what we know now. So that's that. I think those, off the top, from my experience, those are the things that I reflected on.
So
Yeah,
you're touching on.
oh, sorry, Ken, I didn't
I'll
mean to
give my
cut you off.
response. Mine's a little shorter. So it affirmed, the circles affirmed the integrity of the reports, and to me that was a great relief. Uh, yeah, that's my, my brief response, but it's significant. While there was new information, nothing said, "Oh, we should have included that in the report." So I'm very happy that that transpired the way it did.
Yeah, and I think in further to that, I mean, I'm going to relate back to the Labrador Group Home, and just for all council, I'm not going to name any individuals, but I do want to refer to the fact that there was a number of social workers who, I think for the first time we realized, had raised concerns about the Labrador Group Home during that hearing, and there was information come out about the concerns not just being from the clients, but also from some of the social workers, that was more clearly presented, I guess, maybe at the hearing than it had been before. And like the confirmation that they shared the concerns around bullying, for example. That was not something that I can recollect having seen previously. So I'm just wondering, when it comes to some of those kind of those aspects of the kind of testimony within the hearing that backs up what you were saying, is there any way is there any way that we could incorporate, or do we not need to incorporate anything further about that into the report? Do you feel that the original perspective on that is sufficient there? I'm not disagreeing if you think it is, but
Tara, you would have
Yeah,
on that.
yeah, I don't think as a result of the circle hearings that we would have changed our reports. There's lots of things to emphasize, and I think they were, dealt with or emphasized or spoken about in each, either the individual or the kind of the global report. Yeah, I think that's all I can add to that.
Yeah.
I think the other questions I've had have been canvassed well enough by other council, and given the hour, I think I'm going to leave it at that. So I appreciate both of you, and I appreciate your reports, your time with the clients that I had dealings with, that you had dealings with. I just want to say that I think both of you made a real connection with them. You were a point of trust and contact throughout that. And so, I know you were there as independent investigators, and that was never, they never felt like you were taking sides per se, but I think that they did really have a lot of faith that you brought a lot of concern and a depth of concern and compassion for them and their families to the process. So I just want to say thank you, because that was a challenging bit of work you guys had to do, and I thought it was handled very well. So just my final comment there.
Thank you, Will.
Thank you, Will. It was very good working with you as well, and on all of the the inquiry staff and the lawyers and the family representatives. So.
So that will conclude the pre-recorded portion of Ken and Tara's testimony. I believe I can give an indication from the commissioners that they don't have any questions for them, but I will open it up now in case any of you have any questions or remarks for Ken and Tara.
Thank you. Mestas, would you like to start?
I'd just like to say thank you, Ken and Tara, for all the work that you both did. And there's certainly a lot of information, also a lot of information to work with. So I just want to say thank you.
Michael? Okay, just also to echo my thanks to Ken and Tara for their good work. I think given that I think I speak for all the commissioners say we've read your individual reports each. We've also been attended the hearings, of course, presided at them, and as well as the final report, having read that before and now. We don't have any questions, but just again to say thank you for all your good work.
Yeah, and from me as well, thank you very much. We've worked quite often now with Tara and Ken, both in the hearings and then in separate meetings. So no questions from the commissioners does not mean disinterest. It means that we have great trust in the work you've done, and we can work on our recommendations based on your comments as well as the cross-examination. Thank you.
Thank you very much, commissioners. So this will now conclude Ken and Tara's testimony as we've now concluded their questioning. Thank you very much to Ken and Tara for all your work getting to this point and for being here today. So you guys are free now. You can watch the rest of this if you would like, or you can, take leave whenever you prefer. We will take a quick 5-minute break here now. So just around 3:42 or so, come back. We will then resume with Bill English's testimony and watching his first portion. That will be 1 hour and 44 minutes, so it will take us past our 5 p.m. time for today. I will say for council on the call, most of you will already have seen that. But we're trying to keep within our 3-day schedule, so it will require just going over a little bit. With that, we'll break for 5 minutes and see you guys back here soon. All right, welcome back, everybody. As I said before, we've now concluded Kenn and Tara's testimony. So next on the schedule, we'll be getting into the cross-examination and testimony of retired Judge Bill English, and his research that he had to offer the commission. So that video will be an hour and 44 minutes. We'll play all the way through, after which we will conclude for the day. So we'll go ahead with that now. Thank you.
About 9:40 a.m. It's 9:40 a.m. on Newfoundland time, and we're here on Zoom for the pre-recorded testimony of Judge Bill English. And Judge English, do you affirm that the evidence you give will be the truth, the whole truth, nothing but the truth?
I do.
Would you like to introduce yourself before beginning your presentation?
Yes, I will. In my report, I did include a bio, so I won't repeat all that by any means. But first of all, I want to say I'm very grateful to be here, and I want to thank everybody who's come this morning to take part. It has been a great honor to be involved in this process, and it continues to be. My name is Bill English. Most recently, I'm a retired lawyer. Prior to that, I was a retired judge, and prior to that, I was a retired lawyer. So I've had a few incarnations. A lot of it has involved work in Labrador, and that goes back for me to 1977, when I was working with the Newfoundland Labrador Legal Aid Commission. And it brought me to Labrador primarily because there were no legal aid lawyers, and maybe only one or two private lawyers in all of Labrador at that time. There were, of course, private lawyers who traveled there regularly. So there was no access to legal representation. There were courts, and those courts were operating throughout Labrador as much as possible. So my experience goes back to what I would call the pure circuit days, when the judge would be split half and half, really, between circuits and otherwise. And the experience continued then through the 70s and 80s, both in family law and criminal law. And then after a period out of the province, continued again from the mid-90s until 2000, when I was appointed to the Goose Bay Court. I think my bio says that I lived in Goose Bay in 2014. That's a classic typo. It's from 2000 until 2014. And of course, that's the job. As a provincial court judge, you have to be resident within 77 kilometers of where you sit, which is ironic because much of the time I was sitting well beyond 77 kilometers, but that's the nature of circuit. So my involvement with child protection goes back to the very first time I was admitted as a lawyer in 1976. And in 1976, as you probably know, largely the same system was in place for child protection. The laws have changed, of course, and many things have been amended. But the nature of the proceeding, a civil proceeding where someone is representing, in effect, the government, and someone hopefully is representing a family, and social workers are very much involved with the family. That dynamic has not changed. A lot of things around it have. And I guess that's what we're talking about here, is what has changed, what could change, and perhaps if we're able to say what should change. And that's really where my report comes from. So my interest in this has been very long-standing. And I can honestly say that when I was a judge in Labrador, and it didn't matter where I was, whether it was in a coastal community, an Innu community, or Inuit community, the cases that most bothered me and took my time and attention were the child protection cases. although they were by far the minority, even in those days. But they could not fail to take your interest. And I will say, and this won't surprise the lawyers who have dealt with this, there was tremendous overlap between the criminal work in many cases and the child protection work for all kinds of reasons that you all know about. So often you'd see people in two different contexts at the same circuit, maybe with different lawyers or the same lawyer, and trying to deal with their personal matter and their family matter at the same time. So it goes very deep. I feel very strongly about the need to do this right, and that's where I start from. Now, with that preamble, when I introduced this report, I wanted to sort of take a 10,000-foot view. And so I talked a little bit about, and I won't belabor it for the lawyers or non-lawyers in the crowd. I won't belabor it, but the pure legal perspective is the one I described. It's classically not an adversarial proceeding, but there are competing interests. The common interest is the welfare of the child, and that undercuts everything. And our courts of appeal, Supreme Court of Canada have said that over and over again about child protection. It always comes down to the best interest of the child. And I referred in my report to the recent case of LB, which everybody knows about. But the interesting thing there is that even though the court had strong comments about procedural aspects and delay and so on, in the final analysis, they decided that, as they had to, based on the statutory criteria, what was best for the child involved. So that's where I come from. So the legal perspective is pretty clear and hasn't changed a great deal over the years, really. There is an overlay to that, which I touch on in my report, and there are two overlays. The more important one is the Charter of Rights and Freedoms, and that now is more than a gloss on all of this. And I've kept it in mind when I've been thinking about procedural matters and representation matters and even services, which are not strictly legal. The Charter of Rights is available to ensure basic fairness for everybody. Primarily, that's the parents and the children. But there's also, and I didn't stress this in my report, but thinking about it, there's also the fairness to the community, because the community has an interest in child protection cases that often is not directly expressed to any court. The lawyers can't often speak for the community, although they know the community and they may even come from the community. But there's a community interest in the larger sense of the removal of children, the interference with families in the community has to be very carefully handled for fear of denting the confidence and the belief that the community has in itself and in the justice system. And so that's the background I approach it for. So there's a legal perspective, yes, case by case, but there's a broader perspective, and that's what the inquiry is. Really, what the inquiry is all about is in some ways exploring aspects of promoting the overall interest of the community as well as the parties involved. I also talked about the element of trauma. Now, again, I won't have to explain this to anybody who's dealt with these cases. There are layers and layers and layers, and the inquiry has heard in so many different ways about the element of trauma. It's intergenerational, it's long-standing, it's ongoing. And so dealing with that, coping with that, if you have a legal system that addresses the interests of children and families, then you have to never lose sight of the involvement of trauma. You still have to do the job, and you still have to promote the interests of children, the best interests, but everybody affected by this. And I don't even rule out lawyers and judges. everybody who's involved in this on a day-to-day basis will be aware and can be affected positively, negatively, and all kinds of other ways by the reiterations of trauma that are evident when you hear about how people are living, how they've lived, what's worked for them, what hasn't worked for them. So I referred to some of the more basic sources on that. And one of them deals with the question that we have conflicts about trauma. And I did get a question on that. What do I mean by conflicts? Well, what I mean by that is within our society, and sometimes even within the communities, there's a lot of conflict or disagreement about how to approach the element of trauma, particularly in these cases. In our society, we often, unfortunately, default to a blame system, which helps nobody, a punitive system, which helps nobody. But somehow or other, we have to come to some kind of consensus about how to deal with these. And then the second element conflict is particularly where the trauma brings out behavioral aspects like addiction and violence and other types of potentially harmful behaviors. There's a lot of conflict in our society what to do about that. I remember I referred in the report to an experiment in 2008, well, a consideration really, something called the Innu Healing Path Court. And I was there when that happened. I wasn't directly involved, but we were aware of it. And it was an effort, particularly in the criminal law context, to have a different approach to how you deal with cases involving violence that were believed to have a trauma-based causation, or certainly was a major element. And without getting into all of the details, there was a great conflict in many of the communities and in society in general in Labrador about how to do that. Should you take an off-ramp from the criminal law system, all those kinds of issues, or should you simply deal with a punitive system and preventative system, which in large part is the system that we have. So it's not all clear cut. We know there's trauma. We know it's great. We know it exists in the communities, including in the Innu communities. And yet we don't always agree on what approach to take. So I wanted to recognize that factor because, what options are available to courts, to judges, to lawyers will depend on what society in large part will accept. So those were the sort of 10,000-foot views. And then I delved down into the question of the participants. And I won't go through that in great detail. You know what they are. I'll start where the work starts for this presentation. And that's really in the community with the social workers. And by that, I mean both the preventive social workers and the social workers who end up dealing with the matter when it goes to court. I realize that they may be separate groups, but they all have the same mandate. They all abide by the same legislation. Best interest of children, reunification of the family where possible. All of those principles operate throughout all of these proceedings, up to the point, I suppose, where a decision is made by some judge, which might determine the direction for the children. So I start with the social workers because although they're not legal professionals, many of them have training in the background in laws, particularly for child protection. And those with experience, and there are some extremely experienced people in the Innu communities and throughout Labrador, they all know that the work they do every day, which is largely work of prevention, to some extent it may cross over to enforcement, what I loosely call enforcement, that is trying to set standards, trying to guide people by those standards, and then trying to help them to achieve those standards. That's the work that goes on every day. And without that work, nothing the rest of us do would matter. So having the right people in the right places, enough of them, and being mindful, as they say at the transit station, mindful of the gaps, There are gaps. I don't care what system you create, there are gaps. And being mindful of those and trying to fill them. Lawyers and judges can't do much at the end of the process because all the social work has largely been done. My experience is that once a matter gets into court, you can nibble at the edges, but you don't make, unfortunately, it's very difficult to make great progress as a social worker, particularly if you're in the context of a court proceeding. So I start with the social workers. I move then to the lawyers, and their lawyers involved in these proceedings early. Now, one of the comments I did get back from the report about the report was, what about the question of lawyers being involved before there's a proceeding? And there's absolutely no reason why our current system or any new system, if somebody needs legal advice, could not be involved at an earlier stage. My own experience, and I worked with legal aid for a total of 10 years, over 3 decades. My experience is that people often come to talk to you knowing that something's going to happen regarding their family. And they ask for advice. And legal aid has a duty counsel system, which operates usually from their office, but it can be some other way. And that duty counsel system advises people every single day, long before a proceeding has been involved. However, the problem is in Labrador, and I'm thinking particularly here of Natwashish and the Innu communities, because of the remoteness, there aren't any lawyers who live there generally. If it is, it's an accident. It's not part of the system. And so trying to access advice, forget representation, just advice as in the position of a parent, as you're going into litigation. You're trying to avoid litigation, perhaps. You're trying to negotiate and follow through on things that you're required to do through the job protection process. That, to me, might be a gap that we have to be concerned about, because the legal aid, and I know this only too well, often proceeds only on the application process. And although the current system does represent parents early on at the presentation hearing stage without a completed application, nevertheless, at an early stage after that, parents have to follow through in the application. And yet they may still be negotiating. They still may, for instance, trying to have access to their children, trying to have some involvement with them on some level, or having extended family, grandparents who are extremely important. I don't have to tell anybody how important grandparents are in an Innu community, more so than in any other community I've ever dealt with. And that, getting access for grandparents to children is wonderful, can be wonderful, benefit children, and sometimes to the parents for all kinds of reasons because of family interaction and support that they get. So it is important that the lawyers be present at all stages where legal advice is required. The duty counsel system should address this. But here's my concern, and I'll get more later to some of the recommendations, but my concern is that in Sheshi, that might be possible because people can make their way to the legal aid office in Goose Bay, or they may be in for some other reason in town and they can arrange an appointment, get some advice from duty counsel, talk about what their concerns are, and maybe make some progress. But that's extremely difficult in Natwashish. It can take place by phone or video. People can make an appointment and do it that way. I know they can. But I'm concerned that it's not happening. Presence in the communities, and I cannot say this strongly enough, this not just the circuit presence, but presence in the communities. If you're a lawyer dealing with a child protection matter, it cannot be overemphasized. Judge John Joy and I, who worked side by side for 8 years in Labrador, we tried to follow that principle as best we could. And I think the lawyers did too. It's just that facilitating that, making that happen, whether it happens via technology or whether it happens in person, is always a struggle. And but yet it needs to happen, because if you don't have some kind of presence face to face with the people you're representing as a lawyer, then a lot is lost. And I'm not faulting anybody. I did that work myself, going up and down the coast. I flew into Goose Bay and sat around like lawyers have for a full week, trying to do a circuit, but never getting past Goose Bay for all kinds of reasons that had nothing to do with the lawyers or the courts. I mean, these things do happen. So it's not easy, but making yourself available. I assume everybody knows what they're doing. Everybody's got the experience, the training, and if not, they get it soon after they start. But being accessible, being available, is essential. And of course, there are practical issues with that, which I'll talk about later. The judges, well, there's not a whole lot can be said about the judges. There are 3 of them in Labrador in the provincial court, and the provincial court has control over the cases as much as possible. I mean, it's on their docket. And the provincial court does travel when they can to the communities. The problem is they can't. And this problem has gotten worse. I had 10 beautiful years of traveling from Happy Valley Goose Bay to Sheshie for all kinds of court, including child protection matters. And the Innu Nation and the Band Council and all the officials bent over backwards to make me and others feel welcome. I was given an office by the chief. Lawyers were given meeting space. We were given the council chambers to hold court. So there have been efforts made to accommodate the court, but for reasons that are way out of my pay grade, that stopped in 2010. And so even Sheshie, the easy circuit we used to call it, no longer is served in person by the provincial court, neither for criminal nor family matters. And to me, that was always very regrettable. And I can't say I didn't say that to people, because I did, within the limits that you can, report up the line kind of thing, and try to bring about a change. But that didn't happen. Now, interestingly, throughout all those years, we did travel to Natwashish on a regular circuit. Weather and other things got in the way. But I understand now that it's extremely difficult for the court to do that in person. And I won't go into the reasons, because I can't speak for the court, but I do know from the people I've talked to that having the court be present in Natwashish for child protection matters, it's just not happening recently. And there have been periods in the past when it hasn't happened. And it's my personal opinion that if you're going to try to do the job as judge or lawyer, you have to be there on some regular, predictable schedule. So these are not procedural issues. These are not nitty gritty. These are 6,000 feet issues. If you don't go, you can't do. As I used to say to the lawyers, and I'm sure they were sick of hearing it, they would come up and they'd have to come from St. John's to wherever we were on circuit, particularly Natwashish. Prior to that, Davis Inlet. There wasn't always, easy accommodations, lots of problems. And I would say to the lawyers, 99% of your job is showing up. 100% of my job is showing up, but 99% of theirs was. And that is no less true now than it was in 1977. So I think I need to make that point strongly, because for the sake of the communities, having a court that is willing and able on a regular basis to come to the communities is a great sign of respect and diligence and concern. And I can't put it any other way. I only speak for myself on this, but the truth is it permeates my report, the respect for the communities. And I think we have to find some way to make that happen. Now we're using technology, and I'll talk about that later. We are using technology, and the court's doing what it can do under current limitations. But I just think that those limitations somehow need to be figured out. They're not really working. So the judges are quite willing to do their work. Their work is very defined. It's difficult in some ways, but the standards are clear. So we don't need to talk too much about that. I did talk a little bit about how do court hearings work. And that brings me into a few other issues. There are problems with the hearings. In my time, the problems were greater or more widespread than they are now, in the sense that it was difficult sometimes getting legal representation for hearings. I think to a large extent, the current arrangement through legal aid seems to address that in many, many ways. Representation at an early stage, certainly for presentation hearing, is there. The disclosure that really feeds into those hearings is now more easily available than it was during my time, which, I left there in 2014, so that's a number of years ago. And however, you still have fundamental issues. And it's more important with the Innu that those issues be addressed with Innu parents and representatives and witnesses, for that matter. One of those is, I'll deal now with the in-person hearing. I'm assuming that as many as possible hearings are done in person, or when they are. The question of representation generally succeeds. However, I expressed a concern in my report, and I'll just reiterate it here, that I'm worried about the people who might fall through the cracks. Remembering that we're dealing with a traumatized population in large part, a population that of parents who are young, inexperienced, their education may be at a basic level. They may have finished high school, they may not have finished high school, depending on their situation. Their grasp of the English language is as a second language and not at a high level, because you get to the high level generally through education or experience. And these are young people. They may not have either. Young parents in particular, these are the ones we're dealing with in these matters. So I have a great concern, because when that person comes to court, if they have a lawyer, then they are probably being well served. The lawyer needs to find time to talk to them, to prepare. That can be extremely difficult. I did that as a lawyer. I flew from St. John's to Goose Bay to represent parents from Sheshchi on child protection matters. And the problem is, when do you talk to them? We did not have technology in those days, so that was a limitation. But you have to be able to sit down after you've done your own prep and talk. And sometimes it comes down to actually getting people in contact with one another. That is still a physical barrier to preparation for representation and court hearings. And so lawyers can review the disclosure in their own time, in their own offices, of course, and they can send, by email or other means, or through the Innu court worker, they can send questions to the parties if they want to follow up on things or try to explore options. But to do it in person or face-to-face still, I suspect, is a great challenge. That was said to me, and I don't doubt it, because it was always a challenge. And if you're not prepared for a hearing, then the hearings are much more difficult for everybody. So that's the first thing. I'm talking about the lawyers, but I'm also talking about the parents, because often I sat there as a judge, as I did as a lawyer, and you're looking at the parents. You want to see that they're following the proceeding, that they kind of understand where it's going. Maybe they understand the questions and the answers, but they at least understand what topic we're talking about, and so on. And I often look down from the bench, and I really, I had my doubts, and it wasn't the lawyer's fault. I just thought that the communication that was going on in the courtroom, even in person, was often difficult. And it was difficult for the lawyers to check in with their clients then, because of course the proceedings going on. So I think where you have in our Innu communities, a young, relatively uneducated, relatively unsophisticated person operating in a second language, there will always be challenges. And of course, I haven't talked directly about interpretation, but interpretation is one of them, or the lack thereof, whatever the situation may be. Trying to get qualified, competent interpreters. And I won't go through everything I said in the report. I mean, I went back through some of the old history, some of the new history. And I have gone through this in the Innu communities as a lawyer and the Inuit communities, and also as a judge. I've seen it over the last 40 years, the challenges that exist within the communities and in general. There are interpreters, there are good interpreters. And when they're available and when they are able to stick with the case, that is, go from start to finish, or at least whatever they can, then the court is well served, and the parents, the parties to a child protection matter, are well served. But you have to remember that if you were an interpreter, and I have had this said to me by interpreters over the years, this is the most difficult kind of case for an Innu person, an Innu interpreter, to deal with. I have watched them, and they have come to me in between court sessions and said, this is really hard. And it is hard. And often there's just one interpreter. There's no one to relieve them. They don't get to go outside the courtroom. As you probably know, I referred to a couple of cases, the Sidhu case and a few others from Ontario, where they talk about the standard for interpretation, where you have at least two interpreters, and they trade off on a half hour or hour basis, whatever it is that you can accommodate. Nothing happens in Ottawa in Parliament, and I have friends who do that work as interpreters, without that standard being adhered to. Now, we may not reach that standard, but if you can put yourself in the position of an Innu interpreter from the same community as the parents involved, and knowing all the people involved, having to sit through 1, 2, 3 days of interpretation, then you have a pretty good idea of the challenges. And that's before you get into the content of the evidence. I mean, I think it's demanding. They need to be prepared, they need to be trained, and they need to be suitably rewarded. They are paid, of course, and the good interpreters are brave. That's all I can say. They're extremely brave. And I listed a few of them who were involved in some of the training back in 2007, when there was a real intense effort. And some of those people are still doing interpretation. Some of those Supreme Court and provincial court, high-level matters and ordinary matters. And they're to be commended for what they do. But there aren't enough of them. There isn't enough training. So how do the hearings work? They work according to the quality of the resources. That's all I can say. I mean, not much has changed about the judges in the sense that, the judge is listening and trying to do as best it can. But with the lawyers and with the parties and with the witnesses, there are real challenges. So that's sort of, again, the higher view. Now, my mandate I've set out, I was asked to consider the two two sections of the inquiry's mandate, one on legal representation, and the other one a sort of broader issue on access to justice, the question of delay and related issues. I've touched on these to some extent, but I'll talk about the representation part. I use the expression ready, willing, and able for representation. And I broke that down a little bit because I was really trying to in my own mind, step back from my own experience and just say, well, if you were going to design a system, what would you have? If you're going to have lawyers, they have to be ready to deal with the case. They had to be willing to come to Labrador and to the communities and to deal with the people. That's very important. And of course, they have to be able in the sense that they know enough about the case, the law, the community. Most of them will know about the case and the law because that's what lawyers do. They're very good at these things, getting up and ready. But knowing the community is essential. And, I always felt sorry for the lawyers who flew up to Natwashish from St. John's who'd never been there before and were expected to deal with 50, 60 on the criminal side, 50, 60 people, and maybe 7 or 8 on the child protection side. I felt sorry for them because although they were curious and diligent, it was a struggle to know the community, what was available there. So these are the things that have to be kept in mind. Throughout my entire report, I've been assuming that at some point, through the kind of coordination agreement that the federal law allows, and then structures that are put in place through the Innu communities and through the Inter-Nation negotiated basis, I guess, that the Innu would be taking over, in large part, the child protection system. When that happens, hard to know. But to me, that's the future. I always thought it was the future. I often said it was the future, and now I'm convinced it is the future. But when you're looking at the question of representation, you need qualified people if you're going to function in a court setting, and those people have to be selected on that ready, willing, and able basis. That's the point I wanted to make there. The quality of the legal representation, a lot of that has to do with the timeliness. As I said earlier, you have to know your client and know your client's community if you're representing parents. The social workers who are dealing with the children and the parents also have to know the community. Now, I have to say that seems to have considerably improved. Been lots of developments, partly through IRTS involvement and the coordination that goes on now between the social service providers working for government and the IRTS people in the communities. That coordination has solved a world of issues and probably will solve more once it's further developed and further resourced. But we didn't have any of that in earlier days, and it really showed. So we need to escalate that. And lawyers need to have the relevant people involved on speed dial. They need to know who to talk to, who to ask questions to, and when. So the timeliness can be an issue. The effectiveness, I talked about that, just being the lawyer on the case, of course, that's the start of it. But it's a burdensome process. I mean, there's tons of disclosure to be reviewed. It's often can be redacted. If it's not redacted, it can still be difficult to follow. A large part of that is notes that are made by the social service providers over the years, sometimes other types of information. I mean, it's a lot of work. It's not an easy job. So those are the key elements of legal representation. I think Legal Aid's doing a pretty good job. They've got dedicated people who've been there a long time, who know the communities. And but it's inevitable at some point in time, those people will probably pass on to other duties, and it'll be essential to have people following behind them who have the same depth of knowledge, or at least have a means of getting that knowledge. What people don't often realize is that although we have two Innu communities, primarily in Labrador, and of course there's a large Innu presence in St. John's, but I'm just dealing with the Labrador residents, they are quite different. I mean, there are important differences in those communities, aside from the fact of one being close to larger communities and one being remote. The way that they've evolved, the services they have available in the community, the access to transportation, to professionals. And I'm thinking, when I talk about professionals, of course, I mean legal professionals. But, and I haven't really stressed this, but an awful lot of what we're dealing with is health. The social determinants of health are alive and well. I referred in my report to the wonderful report that was done on the Inuit communities in 2019, A Long Wait for Change, by the child advocate, child and youth advocate at the time. That's an amazing report. And I was just browsing through that yesterday to bring myself up to speed. And for instance, they have a section, I'm looking at 16 and 17 of their report, where they talk about the socioeconomic context of their communities. They're talking about the Inuit communities. And they go through the percentage who live in crowded homes, the percentage who are food insecure, the percentage of growth in the communities, the median income being quite low. All of these things, I'm sure the inquiry has gone through its own parameters and work and is well informed on these things. But all of these things, although I haven't stressed them, they all come down ultimately to physical and mental health conditions. And having access to appropriate physical and mental health when you're dealing with either parents or children is crucial. So the situation in Natwashish, where they have a clinic and they have good professionals in the clinic, cannot be compared to the situation in Sheshi, where they have a hospital that's approximately a half hour, 40 minutes away. So all of these things make for differences in services, differences in options. I'll give you an example. I had, when I was a lawyer dealing with some of these cases, I had a number of clients who obviously had severe addiction issues. They admitted it. They were on lists. The ones that were in Sheshi could drive to a counselor to get an assessment done. And they often did. And I encouraged them to, and the social workers encouraged them to. However, if they were in Old Davis Inlet or in Natwashish, to get the kind of assessment they needed, or to get the kind of treatment they needed, forget medication, it was very difficult. They had to get on a plane, sometimes go to St. John's. So the point I'm making is that the solutions to many of the family problems and personal problems are not all in the hands of the legal system. Of course, they're in the hands of the health system. So an integrated approach is essential. And as a lawyer, you have to know the parameters. As a judge, you have to have some idea of the parameters available to the people involved. So when you're trying to make progress in legal representation, this is the information that you need at your fingertips. You can't solve all of the problems, but you can direct people to the solutions that are available. And you can perhaps support them. Now, I wouldn't say lobbying, but you can support them in trying to get that. For instance, a letter from a lawyer, without going into detail, with the client's consent, sent to the appropriate person saying, this is urgent for this child protection case, that this thing be done, whatever this thing is. could be an assessment, could be a conversation. That can be a tremendous help. So having enough knowledge to know that. Of course, there are resident lawyers in Goose Bay, and there's a resident child and family office, and they do have that knowledge. And this is partly why that system works as well as it does. I'll just turn to the access to justice piece. I won't deal with the great limits. I dealt with the time limit situation, the timelines that are set out in the Act. And I guess you can sum up what I said succinctly, that they don't much help advance the case, but they're not the reasons for the delay of the case. So in a sense, they're kind of neutral to how effectively and efficiently child protection cases move ahead. The LB case said it all. The LB case involved an Indigenous person who, had issues, obviously, and children had been removed. And it took 16 months from the time of the removal for the hearing to take place. The Court of Appeal made its comments about that and it expressed its concern about it. And I totally understand it. But one of the circumstances that I pointed out, I think perhaps in a footnote in my report, is that the person who brought that case to the Court of Appeal was not represented at the Court of Appeal. I don't know why. I can't comment on that. I just don't know. But a very important issue was advanced before the Court of Appeal related, to the children and the merits of the case, but also to the question of the delay and what contributed to it, so that the court had a thorough understanding of it. But that person was unrepresented. So it just goes to show that although everybody's trying to be helpful here, there are gaps. There are gaps both at the trial level and at the appeal level. And, we're better serving the children of the communities if we recognize those gaps as existing. But I thought that the time limits were not realistic. I'm not the first person to say that. It's been said by many. The court has some discretion on it, and judges frequently exercise that discretion. One of the big factors with the timelines, of course, is often the need for treatment of some of the parties involved. It could be one of the children, but that's not usually the case. It's usually one of the parents. And if you think that you have two parents, and one may have some issue that needs to be addressed, some serious issue, and the other one may not have that issue. So it's the lowest common denominator in terms of timeliness, because the one that is slowest to deal with the issues that will allow them to even go through a hearing, to participate in the hearing, to be able to speak at a hearing, for instance, pay attention. That person will slow down the other person who doesn't have that issue. And this is, the lawyers who are involved in that know this is a common refrain. And it's not just in Labrador, believe me. I had occasion before I finished up as a judge to sit outside St. John's in other smaller communities, sometimes for up to 6 weeks at a time. And I can assure you, the exact same issues prevail. Just that in small communities, those issues have outsized consequences. And that's the thing, I think, that people ask me a lot because of my presence in Labrador. Why is the situation in Labrador the way it is? And they're talking about the Indigenous communities, particularly on the coast. And I said, the exact same problems exist in those communities as exist in our communities. Just that two factors. The incidence is higher per capita, and the remoteness and lack of services means it's hard to deal with. And I try to explain that over and over again to people who do ask me that question. The lawyers know this, and judges know it, everybody knows it, but you cannot lose track of the outsized effect, particularly in the Innu communities, of some of these social problems that exist everywhere, perhaps in a lower percentage of incidence than in communities that are affected by intergenerational trauma poverty, deprivation, and to a certain extent, isolation. So anyway, that was the timeline issue. I know this is being reviewed. I gather it is being reviewed by the province at the present time in accordance with the 5-year review of child protection legislation. And I'm sure there are discussions going on I hope there are discussions going on between the communities. Certainly the communities need to be consulted on this. This all ties to some extent with the issue I talked about earlier about circuits. Because you think about it, if you're not able to get to a community for a period of 6 months or 12 months, then any delay that you have for other reasons gets exacerbated. And I fear that could happen or is happening. I won't talk any more about the LB case, except to say that it didn't depend on the charter. As I said, the charter is an overview. The court did not base its comments on the charter. It based its comments on fairness issues, and fairness to everybody involved. But of course, the charter, if it had been properly argued, there was no counsel there for the person that could have argued. But if it had been properly argued, maybe the charter would have, as it happened in other Supreme Court of Canada cases and a leading case in New Brunswick, the charter could have been applied. And the lesson of that is that whatever system is devised here, to deal with these cases, whatever system, the charter will always be a blanket over it. And what I mean by that is that you have to keep charter principles in mind, both when designing and implementing and operating any system of child protection. Because one of the basic necessities of life, in the discussion that I referenced, is interaction with your own family, access to your own family. And so there will never be a time under the charter as we know it when child protection will not, have to comply with charter standards, or at least be held accountable to charter standards. So that's something that, again, the lawyers know, but in the designing and the operation of the system, this is important. There will always be a system. The system, who designs the system is really what we're talking about, and who has input to it and who operates it. But there will always be some kind of a system, a set of procedures. And if that system doesn't work well, then you're dealing with young children here, sometimes newborns. I mean, I didn't belabor this in my report, but the truth is the saddest cases and the most impactful cases are the newborns. And we saw, thank God, I don't think there are nearly as many now as there used to be, but I can tell you, I saw them weekly. I saw apprehensions at birth, right after birth, weekly. And it was very, very hard for everybody. Least of all for me. I mean, but those things come before a judge, and the judge has to authorize the apprehension, and that's still the case. And you just know that has ramifications in the community, not just for the parents. There are at least 2 family groups that are involved in every one of those situations, maybe more. So, you have to have a system that is fair and doesn't invite or tolerate, or as the Court of Appeal used the word, complacency about delay. That's really what we're talking about. Now, I won't go into individually my recommendations. I referenced in my report, because there may be some questions about them, and perhaps that's the best way to address those. I had talked about in the long wait for change, the one recommendation that was made in the context of the Inuit communities, and that was recommendation 31. And I talked about this at pages 1 and 2 of my report. And I just wonder, it's brief, so I'll just read it. The recommendation there was that the Department of Justice and Public Safety engage justice system service providers to explore ways to improve access and timeliness of advice, services, and decisions for family law matters in Labrador, and ensure appropriate supports to implement the plan. This is particularly urgent where communities are served by circuit courts. That's the end of that quote. And that really, in a nutshell, sums up my recommendations too, although I broke it down differently and I tried to address them in a little more detail. But the circuit court situation is key to this. And delivering justice in the communities to the maximum extent possible, especially in the Inuit communities, is absolutely key. Now, that's my personal feeling based on my experience and what I've looked at. There may be people in the communities, who have other opinions. Maybe it's very difficult for the community to have the court coming and dealing with child protection matters there. I understand there are different sensitivities, but from the point of view of the functioning of a justice system and the ability to give parties access to the decision maker and decision maker access to the parties and counsel, being in the communities is essential. And if there's no other message that I get across, is that we have to find a way to be respectful to these communities by showing up. And I think that has been eroded more than I would like to see it, or more than I think is in the interests of justice. And I don't think that's the fault of any of the participants at all. Any of the parties we've talked about, service providers, lawyers, judges, social workers, etc., or parents. They don't control that. I'm sure that the inquiry has other ways to find out, or has already found out from the community, what the feelings of the individual communities are. But my own personal feeling is that if you don't go there, then you really won't understand the communities. So that's my fundamental message. I talked a little bit about, and I've only got a few more minutes here now, and then I'll pass over to questions. The interpretation services. I've argued in my recommendation number 3, that there needs to be a professionalization of interpretation services for Inuit communities. And I would say the same thing in Inuit. However, and I speak for long experience here in those communities, the need for interpretation in the Inuit communities is considerably less, much less, dramatically less than it is in the Inuit communities. And that is a hand of applause for the Inuit communities for preserving to a remarkable extent their language, the use of their language, the introduction to their language. Yes, children speak English a lot, young people speak English a lot, but they all understand Inuit to one extent or another. And that is their language of origin. That's their baby language. That's their grandparents' language. That's the language of feeling, the language of self-expression. And that makes the question of interpretation for Inuit communities dramatically more important. And that's, again, my own personal opinion. But more importantly, it's the professionalization is another sign of respect. Any effort to professionalize interpretation is another sign of respect for the communities. And when I was in Labrador in September, I don't know if you recall, there was a trial going on in the Supreme Court involving an Inuit person at that time. And of course, it wasn't of direct interest to me, but I did go and I sat in on part of that during that week. And I went there really because I was curious about the interpretation situation. This is a Supreme Court, very important trial, significant charges. And the thing that struck me is that, first of all, one of the same people who was doing interpretation years and years ago was still doing interpretation, which was gratifying. This was an experienced person. But secondly, that person was not present. They were not in the courtroom. They were present remotely, and their voice was being broadcast through an improvised speaker system within the courtroom. Now, I have a feeling it took a lot of work to even get that to happen. So I commend everybody for making it happen. But it struck me that even at the highest level of criminal charge, in the most serious court, with highly qualified people all around, top down, and lawyers, that this was the best that could be done. And frankly, I would want to do better than that. That's the way I would put it. Professionalization means not just the training of interpreters and the provision of interpreters, but it also means having the facilities and the in-person availability of interpreters. This is going to take an effort. This doesn't happen by accident. There were the efforts made in 2007, and any of you who know about that know it was a real earnest effort to train both Inuit and Innu interpreters. And it continued over about a year and a half, and some resources were made available. I was involved in a bit of that training. I can tell you that the interpreters who took part were extremely dedicated. They had to be away from their families for weeks at a time, especially those from Natuashish. And they did. And they came and they showed up and they did the work. So it can be done. But if we don't do it, then I worry. I worry about how the courts are going to fulfill their mandate, particularly in child protection matters. Because as I said, if you're going to choose a case that's very difficult, it's the child protection cases. These are the most challenging for interpreters. And we really don't do anything to prepare those interpreters for the emotional load, the interpersonal aspect of it, how to deal with the relatives of the parties involved when they go back to the community. All those things that can happen to complicate their life. We don't prepare them for it. So it's no surprise to me that it may be difficult to get people to volunteer or get paid, but they're not getting paid a fortune. But in effect, they're all volunteers. Nobody's on salary. They show up or they don't show up. And it's not surprising that that's a difficult enterprise. So I think for the Innu community's interpretation for hearings is crucial. My recommendation number 5, I've talked about social workers probably enough. I know that there's some traveling social workers that go to Innu communities, particularly in Natuashish. And I had occasion to meet some of those people. They're wonderful. They're serious. Like they are serious. They're well trained. There's 1,000 things. But the nature of their role is that they're itinerant, they're rotational. And I worry again about the gaps, minding the gaps. So one of the concerns is that what happens when the responsible social worker is not present or available because they're doing something else, because they have another life, and what happens for decisions that had to be made in their absence. I suspect that the burden falls on someone else who perhaps doesn't feel prepared to do it. So the rotational social workers, most of the time that I was in the laboratory, we did not have that. We had social workers that were there, or if they did rotate in, they rotated in from nearby. And they were familiar with the community and they were generally available. I think it's become more difficult to recruit full-time resident people. Obviously it has. And it may require some kind of a premium of benefits or payments for those people, but to me, that yes, give them leave time, give them breaks from their owner's responsibilities, but resident social workers are very important. My recommendation 5 is that parents must be fully seen and heard during court appearances. That is one of my main concerns. So I did experience the transition to video conferencing and phone appearances. That all occurred in the 2000s, of course. And more and more it turned out to be phone for all kinds of reasons. And the reasons are really that a lot of the communities don't have good cell phone or any cell phone connection. Everybody relies on Wi-Fi with their phone or with their other device. And of course, not everybody has a device and not everybody has a phone. And if you're trying to do it over a telephone appearance over a landline, especially from somebody's home, I consider it the lowest common denominator. It's undignified. They can't really pay attention. They've got things going on around them, behind them. They got family responsibilities. There's family noise. There has to be. It's a home. And unfortunately, this is how a lot of the appearances are taking place. And I it's out of the judge's control at the present time, but I've recommended what I call hearing spaces in the communities. There are only 2 communities, and there need to be adequate, safe, high and dry, as we used to say in Labrador. Where are we sitting? We're sitting somewhere high and dry. And that was always good news, because it wasn't always the case. Sometimes you go in, there'd be a leak in the middle of the floor, and you court would end because you couldn't sit under a leak. But high and dry is important, but safety and adequate technology and so on. Now, this I recommended a pilot project particularly in Sheshe, because I think it could be easily arranged in Sheshe. It could be easily installed in Sheshe. I know that IRTS is looking at spaces or considering a future with dedicated spaces for their own purposes that are, a little more adequate than what they have at the present time. And I think that would be coordinating with whatever effort they're making would be the way to address that. Parents need a place where they can go, sit down in a room, and without any struggle, be heard. And ideally, with a video setup that's properly with a good signal, or a landline signal or fiber signal, whatever is possible, the best as possible. Be able to see the judge, see the lawyers, hear what's said, and if interpretation is being used, be able to hear that as well. I mean, that's basic. The whole courts are places to be heard. And if you're dealing with a court process and you can't be heard, then it's not a court. It's a court trying to be a court, but it's really not. And again, I don't fault anybody, because I think these things have evolved without a thorough thought process. They've just happened. Things happen and so on. But I think that is, to my mind, the easiest improvement that we can make. So that if we're going to use technology, which right now is being used, let's make it work. For instance, I know that the court in Moabush, and Judge Stray, who I had several meetings with and who I know very well, is trying to cover Sheshe matters and Goose Bay matters of this kind from a distance. It saves everybody time. It saves everybody trouble. I'm talking about trials. I'm talking about all the many appearances that go on. And they're trying to do it through phone mostly, but also through video. Well, that needs to be easier. That needs to work. And I have sat on the bench and tried to have a person who's, say, in Sheshe on a phone, a landline, take part and be heard. And I can assure you, sometimes it works, but just as often it doesn't. So this is essential. We're going to be using technology. A lot of the lawyers who participate are in St. John's. They don't necessarily have to travel or need to travel for every court appearance. We got to make this thing work. They need to be present, but their clients need to hear them. And my own experience is that that's much more difficult than it should be. And the other thing I would say is that the parents who live in Sheshji, for instance, should not have to leave Sheshji for a 5-minute, 10-minute appearance. This is a terrible responsibility. They often have other children. If they don't have other children, they have a job. If they don't have a job, they're often taking care of parents or grandparents. To take them for a full day at a considerable expense to Happy Valley Goose Bay for what amounts to a 5 or 10-minute hearing, there's no need. The only reason it happens is there's no other way to do it. And again, this is respect for the community. I really think it comes down to saying their time is valuable, just like our time is valuable. Let's make this work. Let's have them be heard. So I have dealt with that in detail, and I think a pilot project is probably the way to go about it. The last thing I'll talk about is the dispute resolution methods. One of my other hobbies, I guess, at the present time is I'm a member of a group that's a nonprofit group that's trying to promote mediation, a voluntary process in family law matters generally in the province. And we've been at this for a few years. So I'm kind of plugged into where that is at the moment. And of course, the Act does have these provisions that are there. I'm not sure they're being used much. I'm thinking of case conferences. They are being used. I know they're being used, but how much they're being used. And then judicial case conferences. I think those are not being used at all in the provincial court. The judges are busy. Perhaps they're not being asked for. Judges don't want to impose work on lawyers and parties, if they're not being asked to. But I really think the judicial case conference, for those cases that are what I would call sticky, what I mean by that is that everybody's done their best, lawyers on both sides, judges, and the parties, and they have not been able to come to an agreeable solution. Not every case can be agreed on. Some cases just require a hearing. But the ones that are amenable to that, the presence of a judge at a judicial case conference can make a tremendous difference. I've been doing this work since the 80s. When I was in California, I went through judicial mediation processes over and over again. And I can tell you the presence of a judge who can make recommendations but won't be hearing your case if it goes to court is very effective in having people rethink their positions, perhaps look at the facts a bit differently, think of solutions and so on. So I think there needs to be a greater effort by all involved to use these mediation services. And I'll tell you why. It's not that the hearing wouldn't go ahead. They're difficult, as we said. They will be challenging. They're always challenging. The interpretation of the whole thing. But the damage that gets done when you sit in a courtroom as a parent and you have to hear, unfortunately, a litany of 2 or 3 years of all of your mistakes, all of your misjudgments, and so on. I mean, I sat there and I watched these parents go through it because I had a better view than the lawyers. They were busy. I was there watching the parents. And I can tell you they get smaller every day. It's diminishing. I'm not saying it doesn't have to happen, that sometimes these things are gone through. But that aspect of child protection hearings does nobody any good. And if it doesn't need to happen, one way to get to the solution is through a voluntary process. Again, everybody has to be willing. A voluntary process, and one that involves a judge will be adequate. And I suggest that, for instance, with these hearing spaces that we're talking about, that a judge from outside Labrador if the local judges were busy and traveling and whatnot, a judge from outside Labrador in the provincial court is just as competent, particularly if it's a judge who's had some experience in Labrador, just as able to help out there. And, with the cooperation of the provincial court and the agreement. A judge is a judge is a judge is a saying that goes around among courts, and that would be one way of dealing with it. It would also get you an earlier judicial case conference, because not all provincial courts are as busy as others. And so sometimes judges there are available and willing to help. So I think that recommendation is one of the underused solutions here for the sticky cases. I'm not saying there will be 10 of these a year. There might be 4 or 5. That's my thought on this. But if that ends up settling 1 or 2, resolving it in a way that people are happy with, then that's a good thing. The other option is private mediation. We do have some fully qualified family mediators in this province. I know of 3 that are practicing mediation regularly, and if you didn't want to do the mediation involving a judge or case conference involving a judge, private mediation is also available for those cases. And at least one of the people 2 of them actually, 2 of the people I know of have experience with Labrador, have worked in Labrador, have traveled in Labrador, have clients in Labrador. So they have a degree of local knowledge, which would be very helpful. So that's an option that isn't often explored. Can't be ordered by the court. It has to be perhaps suggested by counsel, discussed between counsel, discussed with clients, and then arranged. But it can be done remotely. It can be done online. An awful lot of mediation now in this province is being done online. So it's just a reminder to not forget those. Now, the last point I'll make is that I did include in my report some statistics. It's in the footnotes, particularly footnote 31 in my report, and there's a little table there. Because in my mind, I wanted to have some idea, how many cases are we dealing with? Because I've been out of there for a number of years. And of course, things change, and they have changed, and have been much progress made. And so I included the most recent table I had, which indicated that there are 120 Innu children in care, children or youth in care. And that was from March of last year, and that was produced by the government. Now, I realize that the inquiry may have done all kinds of other work, and other people have been doing work on numbers and so on, and numbers historically and the trends. And I can't comment on that because I haven't done that work. But 120 children is still a lot. If you think about it in terms of apprehensions or removals, some of those in cares are voluntary. They're consents by the parents, but some of them are in care. And that's 10 a month, if you were to break it down on that basis. And from the small communities that we're talking about, of course, the impact of that is colossal. Because, again, there are 2 family groups for every one of those children. And those family groups are all interconnected within themselves and within the community. I mean, I was always very aware of that, of how the interconnections in the Innu community is even more intense than in the Inuit or settler communities. It's so intense, and it's so close that when you remove a child, or when a child is taken out of the home, it implicates all these families. So just that, I wanted to make that point because those numbers have gone down, and all signs are that they will go down. But even if they go down to, say, 80, 2/3 of that number, that's still a large number of children. So we're dealing here with an impactful number of families and children in 2 small communities. And those children are the future generations of workers, teachers, potentially social workers, all that kind of thing. The very last point I'll make is that I'm very optimistic, despite all of these. These are comments, but I'm very optimistic about the future of child protection in Labrador. One of the things that makes me incredibly optimistic, and I hope it's still a fact, is that there's a training program going on right now for social workers that I described in the report and in the footnotes, the endnotes. That training program of Innu young people or young men and women to become social workers is an indication of responsibility being taken in the community for the future of child protection. And that wasn't even hinted at in my time there, even the most recent years. The fact that a professional program of that kind can be created, maintained, encouraged, and recruited for is one of they're the daffodils in the spring, if you get my point. They're the sign that that good things are about to happen, and that the resources of the community are being put, and other public resources, governmental resources too, are being put to a good use. So that's the note I wanted to end on. And I have a few other comments I might get to make as I go along, but I'll stop there now.
Thank you very much for that.
Great.
I have, I think, only 2 follow-up questions from that. The first is about timelines. And one of the difficult things about timelines is it's easy to say things need to happen by this time, but it's harder to say what should happen if it doesn't. If you have a case where there's a child and there's a legitimate concern of some sort that the child may be in need of protection, and the timelines are missed for systemic reasons or ultimately due to the fault of the state, what is an appropriate response?
Yeah, that's a difficult one. And so the analogy which we see every day now throughout Canada is in the criminal context. And I described that in my report. I won't belabor it. Obviously, the responses can be quite drastic. In the child protection case, I think some of the pressure is off now because of other things that have happened. For instance, the fact that the children are, to the extent possible, being placed in Innu communities or with kinship homes while the matter proceeds. That, to me, changes a lot, because my concern when I was on the bench, and to a certain extent, but it was more of a concern when I was on the benches, I saw children go far, far away in homes that were so different, they might as well have been on another planet. Because we got information about the homes, and they were good homes, don't get me wrong, but they were so different. They did nothing for the child on a cultural basis. They if anything, they caused loss. So as long as that was happening, those timelines, we pushed as much as we could push as judges, for those timelines to be honored. But if you have a placement of a child in the interim in a fully culturally appropriate home, as close to the parents as possible, with the possibility of family, the parents and extended family being able to have contact, and a child of school age being able to continue in school. That's one situation. But the situation where the child is fully removed from family and culture, and the clock is ticking, I think that's quite different. So in other words, context matters. Now, right now, a judge doesn't have a whole lot of alternative. A judge could force a hearing. I think a judge could say, okay, we've got, the timeline's coming up, and we really have to have the hearing. In the LB case, obviously that's what happened, because there was 14 months that elapsed. And by all criteria, that was well past the timeline. Some judge must have said, let's have this hearing. And they had the hearing and went ahead, and a decision was made. But right now, judges don't have a discretion they don't have a statutory discretion, especially provincial court judges. I referred in my report to the parents' patriae jurisdiction that operates in Supreme Court. So for instance, if you had a child protection case in St. John's in the Supreme Court Family Division, those judges have the parents' patriae jurisdiction, which means that they can make the appropriate order that they feel is necessary in the best interest of the child, and they don't need statutory authority. They would be careful about their authority, but they don't need statutory authority to make that order. In the Supreme Court Trial Division or Family Division, in a similar case, a judge could say, look, I'm exercising my parents' patriae jurisdiction here to order this child placed back with the parents or one of the parents or whatever, while this matter is ongoing, because this has now exceeded the time limit. And I think it's given the nature of the placement or other factors the judge would consider. In other words, they have the power, but in provincial court, there is no such power. And because the Act is a code, then I think it'd be very difficult for a provincial court judge to find a remedy, even in the most demanding case. So I think that's a very real problem. But if you were going to construct an act that gave them that authority, then the judge would have to consider the current situation of the child, whether it's culturally and familially appropriate. And that would be, to my mind, the overriding factor. If delay for some reason is going on, and the placement of the child seems to be inappropriate or inoffensive for that length of time, offensive for that length of time, then I think a judge should be given authority to make an order while the matter goes through completion. I don't think the judge should be able to dismiss the matter. I wouldn't want to see that authority. For instance, in the criminal cases, that authority is there now. But in the family cases, the problem is that it's without a full hearing, you know a lot as a judge and as counsel, but you don't always know what you need to know. And so, but I would like to see the authority to change the placement of the child in the best interest of the child, and cultural factors should play a large part in that. I don't know if that fully answers your question, but that's a very important question, because we used to run up, in effect, be thinking about that, and I probably offended more than a few people in the courtroom many times when at the outset of an appearance, and not just a hearing, but at an appearance in child protection matters, after, everybody introduced themselves and so on, I would ask somebody, usually counsel, unfortunately for counsel, it was usually them, I would ask, where's the child? Where are the children? And sometimes the lawyers knew right off, and other times they had to ask the social worker, or the parents. And believe it or not, there were many times the parents did not know either. And this was months into the process. And the reason I asked is because I didn't know. And it always made a difference. If they were 1,000 kilometers away in St. John's or some other place, no contact with family, no visits, no prospect of them, my alarm bells went off on the time question. Right away, I realized that child, especially a 5, 6, 7, 8-year-old child, or even a teenager, there is wear and tear on that child, which is directly related to the effects of the delay. So knowing where the child is was always a prime consideration. And all of these measures have been taken now to have the child close to family. To me, healthiest thing, absolute healthiest thing. I've often wondered why we couldn't solve that many years ago, when we were sending children far away from Labrador. I could go into that, but I won't go into it. There are many reasons why institutional answers to that have not been considered or have been ruled out. And I know more about that than I should know. And I've referenced some of the reports that have dealt with that. I know a lot of the people involved and children involved and the parents involved and all that kind of thing from many years ago. But so there are institutional, there are problems with institutional answers, and individual homes and maybe a group home arrangement are thought to be a more humane answer to delay or interim care. But to me, the solution is being in the community, however you arrange it. If you're close to family and community and your siblings and your peers and your school and your childcare arrangements, then a lot of good things are happening for the children involved.
So, to some extent, one might think that goes to mitigating the harm of missing the timeline.
Right.
But for a parent who finds themselves, they're told, if you want to hear a prompt hearing, it has to be short. Or if you want a hearing within the timeline, we can't guarantee you'll have a lawyer.
Right.
Or there won't be an interpreter.
Right.
They may find themselves in that kind of, if that kind of case arises, you have a choice between your statutory rights and the fair trial you were hoping for. And so I will go back to the question one more time just to see, because can you envision any sort of remedy, anything that could be done for parents who find themselves potentially in that situation?
Oh yes, I mentioned in the report, one of them is that, the matter could be, you give the court a power to dismiss, because you see, it can be dismissed without prejudice, much as happens sometimes in the United States. The last things are dismissed without prejudice, and that means they could resurface if necessary, or somebody with authority thought that was necessary at a later date. So if you had a dismissal without prejudice power, then that effectively would mean that the children are returned to either to the parents or to some suitable caregiver. And if there's a thought that is still necessary for the protection of children to refile, to recommence, then it can be. That way, the parents are out from under the immediate burden of the delay. But it doesn't mean that the children won't be protected. Obviously, the child protection operates at all times. And regardless of whether there's a proceeding going on or not, there are social workers who can intervene, and a proceeding can be pursued. So without prejudice dismissal, I think would avoid the harm of sort of letting go of the family totally, or letting go of the responsibility. I mean, the legal responsibility is there, but I could see a judge in appropriate cases being asked to do that, and perhaps being convinced that that is in the best interest. Because if you think about it, the judge is still required to make the order that's in the best interest of the child. And if the delay is operating against the parents and the children, or both, or one of those, then that order is in the best interest of the child. The same criteria has to be applied. Judge has to feel that you want to treat the parents fairly. This is where the charter comes in, by the way. And because the charter is that overlay of fairness, and it will always be a basis for asking a judge to intervene and make an order, even if the statute appears to limit the power to do so. So, that's why I said any system you devise, you'll have that blanket of the charter and the fairness requirement there. And I think that, that's still a possibility theoretically and so on under the current system. If counsel wanted to argue that the charter now says that excessive delay, this could have been argued in the LB case, but of course wasn't, that in itself now requires a different order in the best interest of the children, to enforce the rights of the parents, because they're not always at odds. I mean, the over time, as the proceeding commences, the interest of the parents and the interest of children can converge, particularly if the parents address some of their personal issues and, and circumstances, which will help the children. So you can, if you have 10 months between the commencement of the proceeding and the time a judge is asked to make the order, the situation can be quite different. It could be worse, it could be better, but it can be quite different. So I could see that power, the power to dismiss without prejudice to a further future proceeding.
Turning to my other area. You spoke about the role that the courts play and the practical issues around getting access to judges in the community. You also spoke, certainly, especially in your report, about the importance of allowing Innu to decide or to play a significant role in designing the system going forward. Could you envision a future where the Innu people set up their own institutions without not using provincial court judges to adjudicate these issues?
Absolutely. Absolutely. See, as long as the legal scheme and, under the current federal legislation, if there's a coordination agreement that establishes that scheme and everybody consents and is properly supported and so on, as long as the system that's set up gives clear authority to whoever must make decisions and has the elements of fairness I was talking about, so it complies with the charter, I don't think the provincial court's only required now, or the Supreme Court in other jurisdictions, other parts of the province. It's only required now because the Act requires it. You could have, for instance, and this may not be a totally apt comparison, but I compare it to the workers' compensation system. You may have a totally good claim under workers' compensation. You don't go to court. In fact, you're forbidden to go to court unless there's some, judicial review thing. As a workers' comp claimant, you deal with the board, which is authorized to make decisions. They had to proceed on fairness basis and all that kind of thing. I don't see any reason why it has to be provincial court. And I could see a lot of advantages to it not. I can tell you, and again, the lawyers in the crowd know this better than I do, the burden of the criminal work in Labrador for the provincial court is every minute, every day, really 7 days a week. The lawyers are working on the weekends, the judges are working on the weekends, people are working at night, they're traveling on the weekends, they're away from home, they get stuck here and there. Just trying to deal with an unfortunately enormous criminal caseload. If you got out from under that and you had an appropriate person, properly trained, because they have to have some legal training. So who that is and how it's established, that's a different issue. But as long as they're someone who were properly vetted, I would suggest there be more than one, for sure, because you will have conflicts because of the familial connections and the community connections. But if you had that, then you would escape the burden of all the other work that the provincial court does. And that has been, and now particularly because, as I discussed in my report, because of the Jordan line of cases and so on, the pressure on the provincial court with criminal matters and the Supreme Court is awesome. That's a pressure you get reminded of every single day when you sit in the provincial court. So it's unfortunate that parents and children get caught up in the demands of that system, because that system will always, in the public eye, the criminal system will always draw more attention than the family court system. And I discussed the fact that family court hearings are closed. I've always had mixed feelings about that, by the way. In England, they're not closed. And however, there's a restriction on identifying parties or in any way. And I read regular reports from the family courts in the Guardian and other newspapers, where very good reporters go and they report the circumstances and the limitations so that the public knows what goes on, why people are in the predicament they're in, and what keeps them from getting out of it, and how it affects children. In our system, anyway, we've opted to have a closed system, and that's fine. You know, I think it isn't hurt by that. I wish the public knew more about it, but that's just my personal feeling. So yeah, I think I can certainly see any Indigenous group setting up a system. I suggested, for instance, in the involvement of elders. I mean, I see tremendous strength in that, of having elders involved as advisors, much as this happened in the criminal context, with a person who's qualified as a hearing officer or a decision maker or adjudicator, whatever you want to call them. Yeah, I think that is the ultimate evolution of an Indigenous system, is to have the Indigenous people take responsibility. It's a heavy responsibility, don't get me wrong. Whoever takes on that job is going to have a heavy job to do, but it's probably one of the most important jobs in the community.
Thank you. Before we I turn things over to the other parties, you mentioned you might have other remarks. Is there anything else?
Yeah, just very briefly. One of them I wanted to make, it's a general statement, but I've hinted at it. Circuit courts are fragile. Local involvement of decision makers is fragile. It can disappear overnight for fiscal reasons, for neutral reasons like weather, accommodation, all those kinds of things. And I don't think we realized until recent years how fragile it is. Technology has saved us from the full realization of that, because we have ways of attempting to keep in touch and communicate. But whether you go with a totally different system or a variation of the system we have, presence and hearings and involvement in the local communities, that principle, I think, any system should establish that principle, unless everybody agrees otherwise. I mean, if everybody agrees that a Natrashish matter will be heard in Sheshchi or vice versa, because, you know, it's convenient or it's reasonable or there's other things going on there that make it reasonable, that's one thing. But I don't think it should ever be imposed on an Indigenous person to leave their community solely to have a hearing that they've been required to attend. I always felt bad about it. And I'll tell you one very quick story. One of the very first cases I had in 1977, criminal case in Happy Valley Goose Bay, was a very serious criminal charge involving a person, a female from Sheshchi. Very, very serious charges. And so I flew up and I had met with my client on the phone, because that's the only way I could do it. And of course, 1977, the road in the spring was impassable. It was a sea of mud. And so when we got there, my client was not there. Talk about access to justice. The judge who was there, who's now retired, he arranged for a helicopter to fly to Sheshchi from Goose Bay. And I insisted on being on that helicopter, and I did. And we landed in the community of Sheshchi in a helicopter. It must have frightened everybody to death. And we took my client back for her hearing, which went on for several days. Had to arrange accommodations, the whole thing. I mean, how basic is it that, you know, you get to court where, you know, or your hearing is where you are if you can't go. It turned out that lady was about 8.5 months pregnant. And that's the reason why she couldn't come over the terrible road. And so, you know, through technology, helicopters, we made it possible. But that was a lesson to me of all the challenges that exist in Labrador. So I think having hearings in the local community, particularly if they're involving local people, I mean, either as adjudicators or as social workers or as parties. That's the solution to all of that deprivation and really discrimination. I see it as discrimination if we don't fully address that. So that was the other point I wanted to make.
Thank you very much.
So that will conclude today's session of the hearings. We will resume tomorrow at 9 a.m. To proceed with the rest of retired Judge English's testimony before we get into the presentations by Dr. Fallon and Dr. Black. Thank you everybody for your attention today, and see you tomorrow at 9:30 or 9 a.m. Thanks.
Here's the vehicle. Oh, good. Yeah, I'll just fill it in.